ও আচ্ছা আচ্ছা, তা কি করবো কোনটা? এ তো হ্যাঁ, ঠিক আছে।
My lord, may I be permitted to mention a matter for
No mentioning,
not
please.
for release, my lord.
It's appearing in the list.
Yes, madam. Item number
Oh, then done.
135, my lord, of today's list.
Original or appellate side?
But appellate side.
Original কে দিতে হবে? ঠিক আছে, অরিজিনাল আছে। To be mentioned for release বলে আসবে। ও আচ্ছা, হ্যাঁ, না না, যেদিন আসবে to be mentioned for release বলে আসবে। ঠিক আছে,
I'm grateful, your lord.
thank you.
Listed matter, item number 1, Zafar Hussain and another versus Union of India and others.
Yes.
But I am for the petitioners in this matter.
I am opposing this. I am for
Right.
India books.
I'm for Union of India.
The petitioners has come up in this field, my lord. There's respondent number 3 and 4 has misused the statutory provisions, my lord. That is why this.
Take the microphone a bit towards you.
The respondent number 3 and 4 has misused the statutory provisions, my lord, laid
How?
down under the surface, my lord.
How?
What has happened, my lord? The petitioner in 2018 took a loan of rupees 45 lakhs from the respondent number 3, my lord, for purchasing an office space. But after purchasing the office space, my lord, it was mortgaged to them. Respondent number 3. The respondent number 3 is a non-banking financial company, my lord.
Right.
Around 10th May 2021, they issued a surfacing notice, section 13(2). My lord, kindly come to page number 13 now, my lord.
Yes.
This is a notification of the central government, my lord. Fourth line from the bottom, my lord, middle part. The central government hereby specifies such non-banking financial companies as defined in clause F of section 45(1) of the Reserve Bank of India Act, having assets worth rupees 100 crore and above, which shall be entitled for enforcement of security interest in secured debts of rupees 50 lakh and above as financial institutions for the purpose of the said act. But here the claim amount is below 50 lakhs. They could not have availed the mechanisms of SABYASACHI Act, my lord. But they have issued the notice on 10th May 2021. Thereafter, on 20th October 2021, they withdrew it. And on now, 30th May 2023, they mislead the Chief Metropolitan Magistrate Court of Kolkata and took the illegal possession of the office space.
Please read the entire that notification, the entire clause
From the first.
from the first.
In exercise of the powers conferred by subclause 4 of subclause M of subsection 1 of section 2 of the SABYASACHI Act, and in supersession of the notifications of the Government of India, Ministry of Finance numbers SO 264-1E dated 5th August 2016, SO 4176 dated 27th August 2018, and SO 5391E dated 24th October 2018, except as respect things done or omitted to be done before such superstitions, the central government hereby specifies such non-banking financial companies as defined in clause F of section 40.
Very good, got it. Very good. Yeah.
This is the
So
matter.
show me the letter of withdrawal first.
Withdrawal is at page 44. They withdrew the notice under section
So
service.
withdrew on a technical ground.
Withdrew. Thereafter, my lord,
They
on
said that they would reinitiate the same.
but not initiated. No notice was given thereafter. No notice
Oh,
given.
acha, acha.
No notice given.
Very well.
Thereafter, on 30th May 2023, they mislead the Chief Metropolitan Magistrate Court and obtained order of police help and took illegal possession under SABYASACHI Act. I would kindly see for page 47.
You did not have any notice of anything.
Nothing.
So why didn't you move the tribunal?
But this is a statutory violation, my lord. They have misused the statutory provisions. laid
Statutory
down.
violation is not on section 14. The statutory violation is in the invocation of the Act, SABYASACHI Act. So you have
Yes,
to go
madam.
through the tribunal to say challenge that. And if that is there, section
My lord,
14 is
no-
valid.
that has been withdrawn. No notice was given. Nothing is SABYASACHI Act is not in option, my lord. They have withdrawn the same.
They must have an award under the SABYASACHI Act.
Nothing is there, my lord. Nothing.
Let us hear them. Yes, India rules.
Yes, your lordship, that everything has been complied. Firstly, this application is not maintainable. Your lordship, kindly see the prayer first. No DM order was challenged.
There is no order.
There is no DM order was challenged. Your lordship, kindly see.
There is
prayer-
no order to
prayer
challenge.
two.
There is no order to challenge. Only a
Lordship,
possession.
kindly-
On 30th May, we have been handed a possession notice. They have taken the possession and taken the notice.
How can this writ petition be allowed actually?
But page number 47, my lord, kindly see.
See your reliefs. What is the relief claimed by you?
They have attached the mortgage property.
It's not a tribunal.
There is no order.
This is palpably not maintained with his character.
But there is no order. They have violated. They have misused the use
See
of
your
the
prayers, read out the prayers.
But I have said set aside or cancel the receipt, the attachment of the mortgage property by the respondent number 4 on behalf of the respondent number 3. My lord, there is no order. What to order to challenge, my lord? Only this document we have been handed, my lord,
As per
as per
section-
47.
as
You
per
have got
provision.
copies of the orders and all.
Yes, yes, I have got
them produce.
everything.
You can produce if you are directed.
Yes, 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 I can.
Let them produce.
Prior facie, at least show me something.
That is a chief metropolitan Kolkata
No, not
order.
the section 14 order. Prior to that, something to substantiate that.
Yes, yes, yes.
A DAT was not moved, my lord.
13.2 was admittedly there.
Yes, yes.
But that
32
was
is there.
withdrawn.
That was written.
Thereafter, no notice was given.
So this is the section 14 order.
Yes,
That does not help, my lord.
No, they are saying you did not issue
yes,
a
I understood, your lordship, the
13.2
13.4,
is
they are
not
saying
there,
that
13.4 is-
13.2 is there.
No, my lord.
13.2 is not
32
withdrawn.
you withdrew.
No, not 13.2.
Let
Your
us see
lordship
that.
kindly see,
Please
that
come to
is
this
not
one.
13.2.
All right. A withdrawal of 13.4.
Yes,
So without 13.4, can you proceed with this
They
section
can
14?
take possession.
No, we have
They cannot
given
take
notice.
possession.
today it
13
is not.
Section 13.2 is there.
Is
Let us
there.
proceed on that premise.
Yes,
13.4, you
13.4
issued and withdrew.
then we have issued another one.
There is no.
Have you got a
have
copy
issued-
of that? Any
Now,
copy?
at present, I don't
Otherwise,
have.
I'll have to stay it for a limited period.
No,
Come
your
back.
lordship
Kindly do that.
Your lordship
I'll
kindly
take it
come
up.
tomorrow. I will.
Tomorrow it's
Monday-
very difficult.
Monday
Monday.
I will produce.
Very
That
Monday.
possession has already been taken.
Yes, my lord.
Possession
already
has
taken
already
possession.
been taken. This is the possession of the
Maintain
property.
status quo with regard to the property till Tuesday.
Obliged, my lord.
I'll take it up on
I
Monday.
am not, I am, no sale notice was issued till now.
In the meantime, what can be done?
Yes.
When was
Actually,
the possession taken?
30th May, my
30th
lord.
May,
30th
your
May.
lordship. Your lordship, they have,
Well, don't do anything in the meantime. I won't pass any interim.
your lordship,
Kindly
one-
record it in the order, my lord.
I want to make one submission. In their 13.2 reply, they have admitted that there is a dues. They have paid only 11 lakh.
Even if there are dues, you have to take
No, I
appropriate
have
proceedings.
given. I have
14
not
others
all
are
the
not
documents.
Accordance with law. Acting
Nothing wrong
accordance
in
with law.
একটা order record করে নিন। Learned counsel for the petitioner contents that initially a notice under section 13.2 and thereafter a notice under section 13.4 of the SABYASACHI Act 2002 was issued to the petitioner. Full stop. However, subsequently the section 13.4 notice was withdrawn by the respondent number 3. Full stop. Thereafter, without issuing any further notice or giving the petitioner any notice of further proceeding, the petitioner was dispossessed from the disputed property on or about May 30, 2023. Full stop. Next para. Learned counsel appearing for the respondent number 3 submits by handing over a copy of an order dated April 1, 2023, passed by the Chief Metropolitan Magistrate, Calcutta, in case number MISCS 455 of 2022, that the process under section 13 within bracket 4 was duly initiated, but the same having failed, an order under section 14 was passed by the district magistrate. Full stop. Accordingly, the possession was taken by the respondent number 3 in due process of law. Full stop. Next para. Since a dispute has arisen as to whether the order under section 14 passed by the Chief Metropolitan Magistrate was backed by an appropriate prior proceeding under the SABYASACHI Act, learned counsel for the respondent number 3 shall produce copies of relevant documents to prima facie satisfy the court that there were such prior proceedings before the disposition of the petitioner. Full stop. For such purpose, the matter is so for such purpose and for passing further orders, the matter is adjourned till June 19, 2023.
And in the meantime, they would not.
The copy of the order of the Chief Metropolitan Magistrate handed over in court today be kept on record.
Your lordship, one thing, they have
দুটো
annexed.
copy দিয়েছেন, একটা ফেরত
Page 43, your lordship, kindly come once more. The notice was issued, the notice dated 4/10/2021 was withdrawn. Page 45, your lordship.
Yes,
Thereafter, no
And
notice
your
was
lot-
given.
Your lordship, kindly come to page 43. They have annexed 7/10/2021 possession notice. 441 notice was withdrawn and another notice was given on 7/10/2021. See, they have annexed. They have annexed.
your withdrawal letter is of 20th of
Yes.
October.
Yes, but it is later dated 4/10/2021. That
After 7/10/2021, after the possession notice, you withdrew.
4/10 notice was withdrawn. 4/10 notice was withdrawn and 7/10 notice is there.
Let us
your
come
lordship.
back
They have
on
annexed.
Monday. Let us see.
Yes. Deeply.
I'm not passing any interim order. Please don't do anything with the property then.
Tomorrow
At
is
least till
Saturday,
Monday.
Sunday, my lord. That
No, if it can't be taken up on Monday, at least till Tuesday, don't do anything.
let it be on the same position, your lordship. That will be
Position, original side,
It will be taken at
It
3
may-
PM. I think.
3:30, I think. 3 p.m. Not 3 p.m.
right.
Item number 2,
Oblige, my lord.
Mohammed Ibrar Haq versus CSC Limited and another.
My lord, I am for the petitioner.
Yes, please. What is the matter?
Lordship, this was for refusal of the power supply at the petitioner's premises. But in view of this order, my lord, I will not ask my lord to pass this order because on 14th, my lord Justice Amrita Sinha passed an order that no supply of power can be given to the premises without the leave of this court. So,
Take the leave of Justice Sinha.
lordship, then
So you are not pressing this.
I'm not pressing this now.
I'll record this. I'll keep this on record.
Lordship, because unless this is being pressed, I will. not-
Otherwise, you won't be able to.
Yes.
Yes, Mr. Mukherjee, any strong objection to
And only a copy may be handed over the order copy.
Order.
either give a copy or please give the
Yes,
details
sure,
at
I have
least. Thank you. No, Suman. Learned counsel for the petitioner submits at the outset that in another writ petition bearing WPO number 2346 of 2022, a coordinate bench has observed that no fresh electric meter connection shall be provided at the subject structure without the leave of the said court. Full stop. Next para. In such view of the matter, learned counsel for the petitioner submits that the petitioner shall ask for such leave before the said coordinate bench and, as such, the present writ petition need not be pressed further. Full stop. Next para. A copy of the order dated June 14, 2023, passed in WPO 2346 of 2022 be kept on record. Full stop. WPO number 1281 of 2023 is, accordingly, disposed of with the liberty to the petitioner to approach the coordinate bench for appropriate leave as per the direction dated June 14, 2023, passed in WPO 2346 of 2022. No orders to cost.
Extremely grateful.
I'm grateful.
For hearing.
Yes.
Item number 3, Alpha Stitch Art Private Limited
I
and
am for
another.
the petitioner, my lord, kindly not to the Mr. Kishore Thakur is appearing in this matter, my lord.
On the
He is
previous
not
occasion also was time was
Yes, yes, my lord, last Wednesday, he was mentioned before you that he will available in this matter
oh, acha.
today, my lord, kindly not today.
Should have told Mr. Kaur.
No.
Mr. Kaur, I'll take it up Monday, not today only.
Monday, your lordship has fixed the other matter, which was
Acha. Should I
continued.
take it up on Tuesday then? Very well.
But only thing, may I be granted leave to file a supplementary affidavit to bring on record a document which
Very
has
well, Mr. Kaur. Are you, is that prepared already?
it can be filed on Monday. I'll keep
Monday, very well. Then I'll keep the matter on Wednesday. Give them a copy on Monday. And
Yes.
learned an adjournment is sought on behalf of the petitioners. Full stop. Learned senior counsel appearing for the, you are for the respondent number 1.
Yes.
and 2.
1 to 7, my lord.
1 to 7. Learned counsel appearing for respondent numbers 1 to 7 seeks leave to file a supplementary affidavit. Full stop. Next para, such leave is granted. Full stop. The said affidavit shall be filed on the next returnable date with an advance copy to the learned advocate on record for the petitioners. Full stop. The matter shall next be listed on June 21, 2023
Macho.
under the same heading.
Grateful, my
Item number 4,
My lord, I appear-
Avlokan,
I appear for the writ petitioner. But I am on the right side. This is the writ petitioner side. May I hand over a copy of the
Yes.
affidavit and reply, my lord, which is in affirmed pursuant to your lordship's direction.
Right.
I'll tell your lordship shortly what this matter is about. I was a successful auction purchaser in a surface sale.
Mr. Mitra starts, may I make a small submission?
Yes.
My lord, in this matter, my lord, an application for intervention had been made on behalf of, my lord, of an ARC company by the name of CFM,
CFM.
by the name of CFM, my lord.
Yes.
Because, my lord, the State Bank of India had assigned, my lord, its account to CFM. And so we were appearing on behalf of the State Bank of India. It was our contention, my lord, that, my lord, we have assigned the account and therefore, my lord, the defense in this matter, my lord, has to be mounted by CFM. Now, my lord, at the interim stage, my lord, State Bank of India was directed to, my lord, deposit the entire money, my lord, which my learned friend, the auction purchaser, had paid. So, my lord, apropos that, my lord, in terms of appeal court's order, 87 lakhs of rupees, my lord, State Bank has deposited. That interim order is in force. It is lying with your lordship's registry. Now, my lord, against that, my lord, CFM made an application for being added as a party that was rejected. Against that, my lord,
CFM has not made any application for added as a party. It is Phoenix.
I'm sorry.
Asset Reconstruction
I'm
Company.
sorry. I got confused.
I think so, because he's
Yes,
going
yes,
on,
I'm
there's no
really right.
CFM on record.
Yes,
It's
yes.
Phoenix.
It's Phoenix. It's Phoenix. I'm so sorry.
It is rejected, yes, it is
Well,
rejected.
yes.
It is rejected. From that, my lord, an appeal is pending before, my lord, the Honorable Chief Justice. That appeal, my lord, we are hoping, my lord, shall be disposed of, my lord, in the near future. And, my lord, my learned friend is completely protected because the entire money has been put in. I do understand his anxiety that he wants the money back. But, my lord, we have already, my lord, I'll tell your lordship. My lord, we had already, my lord, he had said that I bought the property. So either give me the property or give me the money. Now, my lord, it is our contention, which of course, my lord, your lordship will test, my lord, when the hearing starts, that before the writ petition was filed, the sale certificate of the property was issued to my learned friend by Phoenix. So, my lord, so far as, my lord, my learned friend is concerned, he has the sale certificate of the property, thereby meaning the entire property. And he also has the entire sum of money, my lord, which is lying deposited in your lordship's registry, earning interest. So, my lord, under those circumstances, I was wondering if I could persuade your lordship to
Mr.
grant.
Shah, on what ground was it rejected primarily?
My lord, it was rejected.
When the order is there, if your lordship sees,
Yes.
I've annexed it to my reply.
That, my lord,
I've annexed it to my reply, which is there, my lord.
yes, your
And yeah,
lordship will see the order, but primarily on the ground that
There
there
is a
was no
page
privity of
23.
contract, my lord, between him and
Page 23.
Phoenix.
21 and P23, page 21. And the earlier interim orders passed by the coordinate bench is also there, Justice Rajshekhar Mantha. At that time he had the jurisdiction, later on the jurisdiction was not there, so
Yes,
the addition of parties had to go to Justice Bhattacharya.
Fairly detailed order, my lord, rejecting the application for addition. Starts
And
from
it's
page
similar.
24 of the affidavit in reply.
The State Bank also appeared, supporting the case for addition of parties.
Obviously,
Yes, of course.
Yes.
What is obvious in today's world is very difficult to say. The word obvious is hemmed in with uncertainties.
My lord, if your lordship takes it from, my lord, page, page
Page 21, your lordship
9, paragraph
kindly
14.
reads the entire thing, my lord, because everything,
The-
factual detail has been given and then the ratio. So kindly see from page 21. I will not tell your lordship what to read. Your lordship reads whichever part your lordship wants.
Mr. Mitra, if you agree to this adjournment prayer, then I.
No, I am not agreeing to the adjournment. Otherwise, I wouldn't have troubled your lordship. I would have said I
Obviously.
agree to adjournment. I don't agree to this.
No, my lord, I am not, my lord, asking for my learned friend's concession. I'm making an appeal to court because, my lord, the appeal is
For
pending.
that reason, I'm looking into that.
I am not replying to my learned friend. I replied. Your lordship asked me a question. I replied.
Definitely.
Yes. If he wants to reply on my behalf, he can. 21 and then that was the one order, then 23 it starts. 24. 24 to 30.
If your lordship takes it, my lord, from paragraph 11 onwards, I think follow that.
And the earlier order of Justice Mantha is at page 15. An appeal from Justice Mantha's order was dismissed. They made a recall before Justice Mantha, he refused to recall, and then they preferred an appeal from both the original order and the recall, both dismissed. Only the cost part, Chief Justice said, no. Learned single judge is wrong to impose costs. Because owner has to come to court, even if it's a percentage litigation, he has the benefit. These orders speak for itself, not very little I can say. Very detailed orders given. Why is this?
Yes, Mr. Shah, actually, this is a subsequent event, this transfer.
I'm sorry,
This
Vinod.
assignment was a subsequent event.
Yes.
Subsequent to, it has been recorded by the court also, that
Yes,
this is not only subsequent to the petitioner's payment of consideration, obviously it is, and even subsequent to the claim for refund.
Yes.
So subsequently, it has been assigned
my
to
lord,
some.
that's the subsequent, my lord, that is the point in dispute. My lord, if I just give your lordship 3 dates. My lord, I'll just give your lordship 2 or 3 dates. My lord, 2nd August 2018, the sale was confirmed in my friend's favor. 2nd August 2018.
Yes.
My lord, within 5 days from the date of confirmation of the sale, the borrower, my lord, made an application in the DRT under section 17. And on the application of the borrower, my lord, the sale was stayed.
Sale was stayed with observation, no further steps to be taken. Despite the stay of the sale, they did not tell us, and they took 41 lakhs from us. The entire consideration. If they had told us the sale is stayed, we wouldn't have paid the money. You don't tell us the sale is stayed. You take the money, and thereafter, after 1 month, you tell me that I'm sorry, I cannot give a sale certificate because the sale has been stayed.
Yes, Mr. Shah, after
Yes,
that.
my lord. Now, my lord, like I told your lordship, 2nd August, my lord, the auction was held. 7th August, my lord, the auction was stayed. My lord, on 17th August, my friend made full payment. He made full payment on 17th August. And my lord, by a letter, which your lordship, my lord, will find at, my lord, page 30 of the writ petition, on 14th September 2018. My lord, I informed him that, my lord, there is a pending order of stay. I can't give you the sale certificate. Then, my lord, from 14th September 2018, my lord, there was a hiatus in the matter. And, my lord, the matter was again reborn, subject to correction by my learned friend. My lord, in the year 2021, when, my lord, my learned friend filed a writ petition, and, my lord, said that, my lord, he should either be given the property or he should be given the money.
This writ petition.
Not this writ petition. My lord.
Previous,
I
yes.
think it was a earlier writ petition.
Right.
My lord, that happened, my lord, in the month of, my lord. Yes. So, my lord, we informed him that, my lord, there is a pending order of stay on 14th August 2018.
14th September.
As 14th September, I'm so sorry.
Yes.
I'm
yes,
deeply obliged.
yes.
At page 30 of your lordship's brief. Now, my lord, when my learned friend came to court prior in point of time, the court passed an order directing, my lord, the DRT, my lord, to dispose of the matter within a given time frame. I'm sorry, my lord, before that, let me give you, my lord, one date, my lord, which is extremely crucial. 14th January 2020, my lord, I assigned the debt to Phoenix. 14th January 2020, and I wrote a letter, my lord, to the respondent informing them of this fact. My lord, I'll take your lordship to that letter. 14th January 2020. Now, my lord, the application, my lord, by the learned, by my learned friend, the first writ petition was, my lord, subject to correction again, my lord, in the year 2021, which is after the assignment to Phoenix. And in that, my lord, an order was passed that DRT, you please either decide and come to a conclusion. Now, my lord, so far as the DRT is concerned, the DRT, my lord, the borrower came and settled with the bank, and the matter was disposed of before the DRT. And, my lord, the order, my lord, disposing of the matter records, my lord, that the loan has been assigned to Phoenix. And, my lord, Phoenix is not saying that no, the sale is cancelled. Now, my lord, what is of relevance is that before he came to the court for the second time, Phoenix had already issued the sale certificate. That is, my lord, a part of it. But, my lord, if your lordship is going into the writ, my lord, then, my lord, of course, I'll address your lordship, my lord, not on a piecemeal basis. Your lordship will first hear my friend. My lord, I was only saying that, my lord, Phoenix, my lord, be whatever may be the circumstances, the loan is assigned to Phoenix. They are a proper and necessary party, my lord, irrespective of whatever the learned single judge has held.
They took a risk, Mr. Shah. They took the assignment after in fact, the stay was it was acted
My lord, I'm
upon by
giving your lordship the
the
dates.
sale was acted upon by them.
My
Full
lord,
amount paid.
my lord, I'm giving your lordship the dates. So, my lord, they paid the full amount on 17th
17th of
August,
yes.
2018.
Right.
I informed them, my lord, in September 2019. And the, my lord, assignment took place, my lord,
September 2018 itself.
2018. I'm so sorry, 2018.
Yes.
And, my lord, the assignment took place, my lord, in 2020.
Right.
14 January 2020 is the date of the assignment.
Yes.
Thereafter, since then, my lord, Phoenix has been, my lord, in charge. And Phoenix has issued to them a sales certificate, my lord, in the year 2022. Before, my lord, this present writ petition was filed. That is my instruction. On, my lord, 28/29th March 2022, sales certificate was issued by Phoenix. So, my lord, as of today, my lord, my learned friend has the sales certificate, which means he is the owner of the property.
No.
He has, my lord, the entire amount, my lord, which was directed by Justice Mantha for me to be put in.
So Phoenix has to pay, you see. The
Phoenix
refund
has to pay, although for the time being, my lord, SBI has paid. But, my lord,
ultimately the liability.
ultimately, my lord, I will have to claim back from Phoenix, or my lord, Phoenix will have to pay if at all any money is to be paid.
But Mr. Shah, isn't it secondary your claim against Phoenix or vice versa?
Yeah.
I mean, that's a separate cause of action for you. You have assigned that this situation was there.
Correct. Correct.
You have assigned now that
Correct.
amount has been paid by.
Now, my lord, only thing is, the only issue is that, my lord, if Phoenix, my lord, has, my lord, your lordship will see the time lag. 14 January 2020, I, my lord, assigned to Phoenix. Now, my lord, thereafter, my lord, the delay in the disposal of the matter, this, that, and the other, that would have been, my lord, to the account of Phoenix. And
Mr. Shah, when is the appeal fixed against this
my
refusal?
lord, it had appeared in the just before the vacation. Thereafter, my lord, I think we'll have to mention it, my lord. In all honesty, I
In
can't
the
mention
list,
it.
Mr. Shah, should we wait in this matter for that?
My lord, may I only make one request? My lord, if your lordship would give me about 3 weeks' time, if we can't do it by then, my lord, we'll come back to your lordship. That's my only prayer.
Yes, Mr. Mitra.
My lord, may I just place the order of Justice Mantha first? This prayer was made before the division bench.
What prayer?
Just when Justice Mantha's order was not accepted. So this order has been tested up to the division bench. To my knowledge, they have not gone up to the Supreme Court from the division bench. Kindly see the order at page 15 in my reply.
That is not for addition.
Which is WPO 2166 of 2022, which is the writ petition your lordship is hearing.
That's the interim order which directed.
No,
him to
let
make
me
it.
finish.
Very
I
good.
did not interrupt him.
Yes, yes, Mr. Mitra. You did interrupt him, but no difficult.
No, he can interrupt. Then I will also interrupt. Let me go on like
Continue.
this. Yes, I'll continue.
Yes.
Affidavit of service filed in court taken on record. Okay, no ex parte. By an order dated 16 July passed, and this is the earlier writ petition. This court directed the State Bank of India to refund. Kindly see. Together with interest consequent upon any decision of the Debt Recovery Tribunal and SA so-and-so and the application pending thereunder. The brief facts of the case are that the petitioner participated in an auction sale conducted by the State Bank of India under the provisions of surfacing. The petitioner was declared the highest bidder and paid a sum of 55,19,250 to the authorized officer. The bank has neither given possession of the property nor has issued sale certificate to the petitioner, who is admittedly a third party. The surfacing proceeding initiated by the bank came to be challenged before DRT by the principal debtor in so-and-so, Sancheti Electronics. This is the company against whom State Bank of India. No Phoenix here, State Bank of India.
Right.
Kindly see. The SABYASACHI proceedings came to be stayed, and consequently the sale in which the petitioner third party participated, bank therefore refused to either refund the sale price or execute conveyance of the property or even deliver possession. Very important. This is appeal rejected against this. Counsel for the bank submits that the asset came to be assigned. This is the argument made under the provisions of SABYASACHI to one Phoenix ARC Limited. Phoenix is supposed to have implemented itself in SA so and so. Very well. The said SA1 came to be settled. This is important. Between the principal borrower and the said Phoenix. The settlement was recorded, disposed of on 1st March, recording the receipt of 1,82 lakhs by Mrs. Phoenix. The sale in favor of the petitioner thus became infructuous. Not interfered with the division, thus became infructuous. So on an infructuous sale, sale certificate can be issued. The sale in favor of the petitioner thus became infructuous and the petitioner became entitled. This is the. So I'm relying on this. The sale has become infructuous because if you settle, what remains? You cannot at the same time settle, pay money and then say, I will sell your property. Refund together with mail interest as ordered by this court by its order 16 July. Counsel for the petitioner submits that despite notice, no refund of the said sum of so and so is made. The bank has remained silent and it has been sitting tight over the petitioner's money. Counsel for the bank would submit that they have no liability towards this argument being made before your lordship. Towards the petitioner, since they have transferred the asset and all sums received from the petitioner to Mrs. Phoenix. It is also submitted that the petitioner, despite notice of assignment of debt, has remained silent. Again, same submission being made today. And has chosen not to claim any sums of money from Phoenix. It is also submitted that Phoenix is a necessary and proper party in the instant proceedings. Nothing novel has been said today. This court is not even remotely satisfied, kindly see this, coordinate, with the stand of the bank. The bank has admittedly received sums of money from the petitioner and has used and benefited thereof. The transaction between Phoenix and the bank are of no concern of the petition. This is what your lordship also observed. No concern.
Mr. Shah, I'll keep this matter on Monday and hear it out.
Kindly hear it out.
Post on this ground. I'll record your submission and I'll
Only one thing permit me to point out.
Hmm.
That, my lord, this order is my lord, an interim order directing
True,
a
true, true.
deposit
I'm
of
not going
money
by that order.
and the writ petition is pending. Now, my lord, the appeal that my learned friend is talking about is, my lord, from my lord, this
Your
interim
cause of
order.
action against Phoenix is rather different from this the matter involved here.
Yes,
in this
that is what I'm trying
No,
to
my
You have
lord,
subsequently
my lord, I am not
asserted-
asking your lordship to adjudicate upon my cause of
This is not
action
a
vis-a-vis
necessary party.
Phoenix.
Prima facie, Phoenix is not a necessary party here. For that pendency of an appeal, even if it was the application stage, I could have heard out the application. Since that has been rejected, Mr. Shah, the appeal is pending would be a bit too remote for stalling this matter.
Very well, my
So I'll record my order so that you can challenge this also or show this before
lord.
the
No, my
appellate.
lord, it's- my lord,
Being fair,
no,
so
my lord, I tell your lordship, my lord, if it is your lordship's intention to hear it out, I'll assist your
I think
lordship.
I'll
My
do
lord,
that. I'll give my reasons.
there is, no, your lordship need not even give you, the lordship and keep it on Tuesday, I'll come and assist your lordship.
No, Mr. Shah, I have to give my reasons.
No,
Since you have
that
argued,
that
I'll
is your
give some
lordship's
reasons, at
privilege.
least semblance of a reason, at least I'll give.
that is
some
your-
semblance that matter was heard and
is your
your
lordship's
lordship has,
Yes, but
No,
my lord, the only thing
but
is, my lord,
Various reasons that the matter was heard at least.
for various reasons, from various persons.
Right. The learned senior counsel appearing for the writ petitioner seeks to move the matter, full stop. At this juncture, comma, learned senior counsel appearing for the SBI submits that an application for intervention in the writ petition was filed by a
Phoenix.
third party entity, that is one Phoenix. What is the full name?
Asset reconstruction,
ARC,
ARC.
Phoenix ARC.
Phoenix ARC. Full stop. However, comma, the said application for intervention was rejected, comma, against which an appeal is at present pending before the division bench. Full stop. It is submitted that, comma, in all fairness, comma, the writ petition ought to be adjourned, awaiting the outcome of the said appeal. Full stop. Next para. Learned senior counsel for the bank further submits that the sale in favor of the writ petitioner was concluded on August 2, 2018. Full stop. Thereafter, on the borrower's application for setting aside the sale, comma, an order of stay was passed on August 7, 2018. Full stop. Thereafter, the writ petitioner made full payment in respect of the consideration amount for the sale on August 17, 2018. Full stop. Subsequently, on or about September 14, 2018, comma, the State Bank of India informed the petitioner about the stay and consequential inability on the part of the State Bank to issue a sale certificate in favor of the writ petitioner. Full stop. Next para. Subsequently, on January 14, 2020, the debt DBT in question was assigned to the said Phoenix ARC. Full stop. Next para. Learned senior counsel appearing for the writ petitioner controverts such prayer for adjournment and contends that in view of the orders passed in connection with the writ petition previously, as well as the rejection of the intervener application, comma, the writ petition ought to be taken up for hearing. Full stop. Next para. Upon a prima facie consideration of the submissions of learned counsel, comma, it is evident that the assignment in favor of Phoenix ARC took place subsequent to the cause of action of the for the present writ petition having arisen. Full stop. Next para. As on the juncture when the assignment took place, that is on January 14, 2020, comma, it transpires that the petitioner had already had a concluded sale in the petitioner's favor. Full stop. That apart, comma, the claim for refund and the cause of action for making such claim had already arisen. Full stop. In any event, comma, the claim of the SBI against Phoenix, comma, in view of the fact that the SBI has already paid the due amount deposited the due amount in an interest bearing account with the registry of this court, comma, lies in a separate proceeding from a cause of action which apparently has arisen subsequent to the cause of action of the present writ petition. Full stop. Hence, comma, on a prima facie footing, comma, the claim of the SBI against the Phoenix is a different issue having no direct nexus with the scope of adjudication of the present writ petition. Full stop. Hence, comma, the prayer for adjournment by the State Bank of India on the ground of pendency of an appeal against the rejection of the intervention application. Pendency of an appeal against the rejection of the intervention application cannot be acceded to. Full stop. The writ petition itself, comma, accordingly shall be taken up for hearing on
May I pray for Tuesday, my lord, instead of
Tuesday,
Monday?
on June 20th, 2023. Tuesday.
My lord, only one thing. My lord, I hope, my lord, that, my lord, since your lordship's observations have been so
Don't
comprehensive,
show this to the appellate.
they'll go and show this to the appellate court. I have to defend two orders then. My lord, your lordship is, of
What
course.
should I say? This will not affect the appeal. Mr. Shah, can I say that?
No, my lord, I have not made that submission.
I have
Because since your lordship has
twice-
liberally interspersed the order with prima facie.
I have fished it twice and apparently once. If you say I can add one another expression that all these findings are tentative, but for what purpose? The writ petition.
No, your lordship
Obviously,
has,
these are tentative.
your lordship has already, my lord, used the word prima facie.
I
a
have fished it
couple of-
twice and apparently once. So that will help you.
No, apparently more than once, I think. But that's why I was weighing it in the balance. I'll come back on
Better
Tuesday.
than me, Mr. Shah, because this affects you. Very well.
Your lordship taking up original side at 3 PM from,
3 p.m. from Monday. Yes,
so it will be after 3.
it will be.
Since there are very few original side matters, I
That
will
is
not
why.
be asking for any retention of its place.
No, Mr. Mitra need not, because it will
Don't
be
do
taken
that.
up probably then. And there are so many appellate side matters accumulated already. That's why I'll have to take up more appellate
No,
side
no, no,
matters.
that is your lordship's discretion. How your
That is the reason actually.
the docket, we have nothing to say about the
No,
docket.
not that, but that's why I've kept it at 3. No, 3 means 3:30 risk is also there. That has to be kept in mind.
That we have to also, that is of our choosing.
Not so many matters in the origin.
No, no.
So no
That
difficult.
risk is always there. Whether I live or die, that risk is also there on that date. I may drive for traffic accident, that also is, I may not come. So that risk is always there. We run so many risks in life.
Yes,
So
sir.
one cannot be certain about appearance.
Right.
I'm grateful to your lordship.
Thank
I
you,
will
sir.
not waste lordship's time in.
No question of
un-
wasting time.
Grateful.
I'm grateful.
Item number 5,
5, yes.
Sathi Commercial Private Limited and another versus Union of India.
Lordship, I appear on behalf of the petitioner, Lordship. Lordship, we've tried to communicate with the petitioner, but we could not connect to him. I have no like instructions to appear, Lordship.
So I'll
kind-
dismiss for default if it is
kindly record my retirement from the brief, Lordship.
very well. You are the advocate on record.
I'm the advocate in record, Lordship.
What is your name? Very well, name is not record. The learned advocate on record appearing for the writ petitioners submits that despite best efforts of the learned advocate, comma, he could not contact the writ petitioners and or take any instruction to move the petitioner to move the writ petition further on behalf of the petitioners. Full stop. Accordingly, learned counsel for the writ petitioners seeks leave to retire from the matter. Full stop. But within the provisions, the principles of order 3, you have to approach your client first. But you say you could not approach him.
No.
Very well. Next line, Kodin. In view of the provisions of order 3 of the Code of Civil Procedure and principles akin thereto, having not been akin thereto, having not been able to be complied with by the learned advocate for the petitioner in view of the above circumstances, comma, this court grants leave to the learned advocate on record for the writ petitioners to retire from the matter, full stop. In such view of the matter and in view of the absence of representation of the writ petitioners, comma, WPO 2421 of 2022 is dismissed for default, dismissed for non-prosecution without any order as to cost. Interim order, if any, shall stand vacant.
Grateful, Lordship.
তোমার সুমন অসুবিধা হলে তুমি অন্য কাউকে দেখিয়ে নেবে, তোমার ভুল হচ্ছে খুব।
Item number 6, Shyam Babu versus the state of West Bengal.
For the respondent.
Appear for the state. And it's on the last occasion on.
This was the last chance, yes.
And my lord, the state will be paying for costs because if my lord sees the writ, they have basically made false allegations which have been proved to be false by the affidavit. So my instructions are, my lord, to pay costs, but if they don't appear, to pay for costs, but if they don't appear, I don't know what to do.
I'll record that you're paying for costs, but I'll not grant it.
My lord, if they're not appearing, there's little we can.
There's little scope. None appears for the petitioners. Petitioner at the time of call, full stop. It is contended by learned counsel for the state that the petitioner has made incorrect statements in the writ petition itself, comma, which can be demonstrated from the averments of the writ petition itself. Full stop. As such, comma, costs ought to be awarded against the petitioner. Full stop. Next.
My lord, can be refuted from the affidavit in opposition, not the writ
আচ্ছা
itself.
এর আগের সেন্টেন্সে যেখানে শেষ করলাম which can be demonstrated বলেছি তো, demonstrate পর demonstrated পর থেকে সেন্টেন্সটা কেটে দিয়ে ওই সেন্টেন্সটা demonstrated from the annexures to the or pleadings to
The pleadings and annexures to the affidavit.
demonstrated from the pleadings and annexures of the affidavit in opposition. Full stop. Next para. তারপরে সেন্টেন্স petitioners. Full stop. Next para. However, comma, keeping in view that the petitioner is consistently unrepresented, comma, the prayer for costs are not acceded to, full stop, in view of the order dated June 6, 2023, comma, when the matter was fixed for hearing as a last chance today, comma, it is deemed that the petitioner is no longer interested to proceed with the matter. Full stop. Accordingly, WPO 275 of 2023 is dismissed for default without any orders to cost. Interim order, if any, stands vacated.
My lord.
Thank you.
Item number 7, Lords, do take company private limited and.
My lord, I appear for the petitioner. Lordship was kind enough to grant us an extension of time to file the affidavit in opposition, but the concerned person is very ill. My lord, I was only praying, my lord, if Lordship grants me some more time. My instructions are, my lord, for 3 weeks, my lord. He is not keeping well, but if Lordship
You are
grants.
for the
me a-
petitioner,
I'm for
reply.
the petitioner.
Respondent number 1, my lord.
Affidavit in reply.
They are not
is-
suffering in interim order.
No. I have not got any interim order.
I'll grant that time. When should I, till when, Mr. Dotto, today we are on 16th. So I'll give you
My lord,
time
gives
till
me time till
7th July.
7th, and Lordship may keep it immediately thereafter, my lord, subject to the, my lord,
very well.
convenience of the court.
Learned counsel for the petitioner seeks further extension of the time for filing affidavit in reply in view of the serious illness of his client. Full stop. Accordingly, the time for filing affidavit in reply is extended further till July 7, 2023. Full stop. The matter shall be listed for hearing on July 10, 2023.
Grateful, my lord.
One submission, my lord, if a advance copy can be served upon.
I will, my lord, I will
My lord,
definitely.
we can take instructions from our client beforehand, my lord. the matter
Definitely they will. I'll
Will,
not
my lord.
record
Lordship
that
need
Mr.
not
Dotto is
separate
saying. Yes, I need not. Please give that. Yes.
Grateful, my lord.
Item number 8, Lal, Jajodia and
Right.
others versus IDBI
I'm
Bank
for the
Limited and
petitioner, my
others.
lord.
Right.
The matter was taken up last on 27th April. My lord, directions for affidavits were given. My lord, may I be permitted to file my affidavit in reply? My lord, my senior, my lord, is engaged. My lord is on legs in courtroom number 36.
Who is your senior?
My lord, Mr. Anuj Singh. My lord, if I may be permitted to come back on the next date, my lord, today my senior is not available.
Depending on what they say.
My lord,
Yes.
subject to what my other side said. My lord, I am for the petitioner.
On the prayer of learned counsel for the petitioner, the matter is adjourned for the day.
For the day.
Affidavits in opposition and reply filed today be kept on record.
Much obliged, my lord.
Sorry.
Specially assigned matter, item number 9,
Item number 9, my lord, I appear for the petition.
Yes.
My lord, Mr. N. Banerjee appears for the state respondents, your lordship. He's not been able to come to court because of some difficulty, your lordship. I'm
Not
praying-
being able to come to court.
He's not been able to come to court.
When should I keep it? Tell me.
Any day as your lordship wishes.
Weekends, my lord, Monday week, subject to lordship's.
Monday week.
Monday or Tuesday week, my lord, Tuesday week.
Then it will be on 27th June.
27th. Your lordship will be taking up the original side matters from at
3
at 3.
from Monday. An adjournment is sought on behalf. You are for the respondent.
Respondent.
My lord, only leave may be
Respondents.
granted, my lord. They had filed 2 affidavits in opposition, one to the main writ petition, another to the supplementary affidavit. And we may be granted leave to file the affidavits in reply in the meantime, my lord.
An adjournment is sought on behalf of the respondents. First up, learned senior counsel appearing for the petitioner also seeks an extension to file extension of time to file affidavit in reply to the opposition used by the respondents. First up, accordingly, the
2 affidavits, my lord. One to the main and another to the-
affidavits.
affidavits in reply.
First up, next para. Accordingly, the time for filing affidavits in reply respectively to the application, interlocutory application, as well as the main writ petition are extended till
Well, not interlocutory, supplementary affidavit. I'm so sorry, my lord.
supplementary affidavit.
Affidavit. I'm so sorry. I'm so
তাহলে অত
sorry.
কথা দরকার নেই, affidavits in reply.
Affidavits in reply
Time for
will-
filing affidavits in reply is extended till June 27, 2023, when the matter shall next be listed for hearing. First
So
up,
grateful.
please give advance copies of those to them.
Certainly, madam,
Obviously, need
certainly.
not be said. Yes.
Certainly.
হয়ে গেছে আর 10 মিনিট সময় দিই অ্যাপেল সাইডে কেউ নেই অ্যাপেল সাইড item 2 people are there, 1 not there. I can see item 2 who is appearing. You are there. Then I'll start taking up. You will be asking for time. Then I'll take up the appellate side now. I'll continue with the appellate side.
Okay, permit to mention one thing, my lord.
Appellate side mentioning. Let the appellate side people come first. Yes. Yes, what is the mentioning about?
Restoration application, my lord.
mention some weeks after. Let me dispose of some matters.
Item 74, my lord.
So I refused once, so I am refusing the other.
At 3 p.m., my lord, I am paying. Dr. Madhusudhan Shara is appearing. There is some emergency, my lord. At 3 p.m., my lord.
Is there any 3:30 today?
Yes, there will be.
Then I'll fix it at 3:30.
I'll be no problem.
I'll also be no problem.
Then 3:30.
Very well. এটা 3:15 সময় দেখো item 74.
74.
Please give notice to your other side.
I'll certainly.
Item 74, 3:15, Mr. Haldar. Yes.
Appellate side for judgment, item number 1.
Mr. Chakravarti, has it been communicated?
Well, I do not have any copy of this.
No, I have not communicated them, my lord.
No, why should you?
I can give now. I have a copy.
Give her. This is your communication or the answer?
No, this is the answer. Only the answer I have.
Right. So very well. I'm passing my order final. Thus, WPA 12335 of 2023 is disposed of by directing the adjudicating before the, I'll read the paragraph before that also. Accordingly, there is no scope of entertaining the writ petition at this stage. However, in order to allay the apprehension of bias in the mind of the petitioners, a further opportunity of hearing ought to be given to the petitioners before closing the hearing on the pending interim applications. Thus, WPA 12335 of 2023 is disposed of by directing the adjudicating authority to afford an opportunity of hearing to the petitioners and or their counsel, and thereafter to pass necessary orders. As clarified by it earlier, the adjudicating authority shall also not rely on the rejoinder filed by the ED unless a written objection thereto.
Lordship, absolutely.
No address to cost, urgent certificate.
Lordship, at least some time may be granted about 48 hours or 72 hours, so that we can prepare and do your odd after 7 days, if the date is.
My lord has asked for to give the opportunity of hearing. He will definitely give.
All I am saying,
a proper notice before.
Yes, definitely. It will
Now don't repeat the mistake which was committed previously.
No,
It will not be in the office.
two things, at least 7 days time, and we when physical hearing.
No, I won't specify that.
Because, but what I am,
that is beyond my charter sitting in this writ petition.
Because what is happening there, I have also raised
So
my.
there are several reasonable apprehensions on your part. I have dealt with all of those. Subject to what, I mean, if you challenge it or they.
No, question.
No, why won't you? Subject to what the appellate court said, Mr. Nag, these have been dealt with. I hope they'll be more cautious in future for their, I mean, so that the orders are protected better. Whatever order is passed.
I am grateful, only 7 days.
Are given here.
Only 7 days, time.
7 days I cannot.
Kindly, indicate.
You pray to God, not to the authority. Pray to God that they don't give that time. That will be only helpful for you. If they give that time, Mr. Nag, you lose a defense, one of the defenses.
Lodge.
Great.
Grateful.
I'm deeply obliged.
Yes, call.
New motion, item number 2.
Yes.
Item number 2, Your Lordship, I'm appearing on behalf
You have served on the other side?
Yes, Your Lordship, here's
I'm
the
appearing for
affidavit of-
respondent number 7.
7. Very well. Yes. What is the matter, please?
Your Lordship, just one indulgence, Your Lordship. I was briefed in the matter yesterday. I have yet to find my Vakalatnama in the matter on behalf of respondent number 7.
This is Hyderabad. What is the urgency in your matter? Can it wait till Monday?
As Your Lordship may
Very well.
please.
So I'll keep it on Monday. Learned counsel having instruction to appear for respondent number 7 seeks a day's adjournment to enable him to file his Vakalatnama, full stop. Accordingly, the matter is adjourned till June 19, 2023. Please file your Vakalatnama either during the course of the day or at least
Monday
morning. Yes.
Absolutely.
Thanks. Give your names, your name also. Call on the next one.
Item 3.
I'm for the petition.
Yes. What is the matter?
The petition, this is my everyday service. The petition.
Good service.
The
Petitioner?
petitioner is a guarantor of a loan
Yes.
in favor of respondent number 4.
Right.
Lordship, connection with the loan, he furnished a title deed as security. Apart from this petitioner have two MIS in the particular bank, and he paid for prematurity of the same, but that was not given on the plea that the loan account requires more additional security. That was never placed before with the bank. Now, his prayer for premature was refused verbally. Suddenly, prayer for prematuring of this.
Oh, you wanted a premature withdrawal?
No, that was refused. But what they have done, they have prematured it and credited the amount to the loan account. It was never placed. But I made a prayer.
Go
Nothing
before
is
the tribunal.
No. The only 13-2 has been issued.
Yes.
I have no right to move before the tribunal.
So what is the scope of this? I mean, what are you asking for? Stay of this deduction?
I
Then I'll
want
have to direct affidavits.
I want refund, my lord, with interest.
Refund without giving them an opportunity of directing affidavits. At least hearing them, I won't give. Either I can direct affidavits today, or you can give another notice and come back. If
As
they
your
don't
lordship.
appear in spite of another notice, then I may consider deciding the matter.
So I can serve another
Give
notice.
another notice. I'll record that in my order that you are appearing, but they are not. None appears for the respondents despite service. The affidavit of service be kept on record. Full-stop. Learned counsel appearing for the petitioner submits that despite certain policies of the petitioner lying with the respondent bank, but not having been given as securities for a particular loan, comma, while refusing the petitioner's request for premature withdrawal of such unrelated amounts, comma, the bank itself ensured that the same were terminated in a premature manner and debited the said amount from the petitioner. Full stop. Next para. The challenge in the writ petition has been preferred against the same. Full stop. However, comma, as a last chance to the respondents to appear and contest the matter, the same is adjourned till June 19, 2023. Full stop. The learned advocate on record for the petitioner shall serve a notice to his counterpart appearing for the respondents and/or the respondents directly, indicating that the matter shall be taken up peremptorily on June 19, 2023. Full stop. A receipt in that regard shall be filed on the next returnable date.
Probably by 19 service will not be affected.
No, I also think so.
Today
Then
we are
21st.
also 16.
21st?
Let it be taken up on next Friday.
Next Friday,
One
very
day.
good. তাহলে 19 যেটা বললাম returnable on June 23rd. 23rd June.
Let the matter remain in its same position. Grateful to you.
Thank you.
Item 4.
Yes.
My lord, I am praying for Passover.
Why?
Learned advocate is appearing on this matter engaged in another court. Lord, kindly pass over this matter on 2 p.m.
My lord, I'm representing respondent number 5. He only contacted me yesterday. So I just pray for some time.
Your client contacted you properly. So I'll keep it when Monday.
My lord, I have to file an affidavit in objection. So please keep this.
Opposition, I may not permit you also. So let us come back on Monday and let us see. Take your instructions in the meeting. Pardon?
In this matter, my lord, I also agreed with my learned friend. My lord, there is a we should file an opposition where because there are already.
Let us senior move the matter first, Mr. Otherwise, she'll be in difficulty. On the prayer of the petitioner, the matter is adjourned till June 19, 2023.
Grateful.
They are not enjoying any interim order.
No.
First time moving.
This is coming up for the first time. There are other two writs petition. One has been released, my lord,
What?
and another matter, my lord, which may be, my lord, we tagged along with this matter, my lord.
That is pending before in my court.
My lord, there was
So
a
tagging we will consider on Monday, Mr.
Local itself.
I've not given said anything in my order. Do it and file entry. Give you an entry number on the next.
Grateful.
Okay.
Next.
Item 5.
I'm for the petitioner.
Yes, please.
My lord, I am appearing on behalf of the state, Lords.
So far, my lord, the private respondents, my lord, is concerned, my lord, 4 have been received. I have prepared my lord, affidavit size, my lord, could not affirm, my lord. One, in respect of one respondent, my lord, it is not complete.
Which respondent?
It's now 7. Allegation is, my lord, encroaching, my lord, the public road, my lord, they have made construction. I have-
7 is the main respondent. You're asking for a relief. Relief means that they'll initiate a proceeding against 7.
I have an innocuous prayer. Let them proceed, initiate proceeding.
Let me hear them once. The state, yes, what is it?
Lordship, this is the case, Lordship, where the petitioner's allegation is that the illegal construction is being carried out on the public premises, and the electric connection was sought for by the But in that case, the petitioner's objection is that, in spite of application, that is on page
23.
23, Lordship, objection was raised. In spite of that, the concerned licensee is not doing in respect of the application. Objection is that so that the connection is not being made.
Lordship, kindly come to page 25, paragraph, my lord, 5. Have I made specific allegation, my lord, which was required to be taken care of by, my lord, the executive engineer, PWD Road. Let him initiate proceeding under 64 Act, my lord. If it is found, my lord, there is, my lord, encroachment of the public road, they will take initiative. Otherwise, my lord, they will dispose it off.
But it is the connection for electricity.
No.
Serve on the private respondent.
Yes,
Come back. I'll take it up on
Tuesday, my lord.
Tuesday. I think that will be. It is fairly submitted by learned counsel for the petitioner that the private respondent number 7 has not yet been served properly. Full stop. To await such service, let the matter stand over till June 20th, 2023.
Let the matter retain in the same position.
Cannot retain position, but it will be on the list. Let us see. This is a, vexatious litigation to trouble your neighbor.
No, my ingress and egress, my lord, have been
Hate
totally
thy
blocked.
neighbor.
No, my ingress and egress are totally blocked.
And respect of determination, Lordship, so far concerned, it is.
They're very determined to harass you.
Oh, Lordship.
Next
My
one.
lord, they are not going to harass, my lord. If it at all, my lord, that is a private.
Yes.
Lordship, grateful, Lordship, much obliged.
Item 6.
6.
So, my lord, I led by the Mr. Dilip Kumar Samant, my lord, short for kind of.
No, move the matter. Move the matter. You have the file, move the matter.
My lord, I am appearing for respondent number 1 and 2.
Very good. 1 and 2 means the Union of India.
Yes, my lord.
What is your defense in the matter?
My lord, I have nothing, my lord. Entire allegation is against the respondent number 3, Tata Motors. It's regarding a vehicle.
You are for
issue.
Tata Motors? Oh, you are with them. Tata Motors has been served properly, you don't know.
Every day service there.
Good service?
Yes.
Checked
Sir.
up?
Yes, sir.
Very good.
Service.
What is the matter?
Well, this is a case of illegal possession of my car.
Illegal possession of?
My vehicle. Achha. My lord, I took a loan from the respondent number 3 and I repay 12 lakh loan. My lord. I repaid 11 lakh out of 2 lakh, but I fail 1-2 installment, and they, without any notice, they repay of the car, and they did not comply the guideline of RBI. They did not serve any loan agreement, my lord. Until and unless I get a loan agreement, I cannot comply the entire amount. No notice was served upon me, and on the road they repay of the car.
Then I'll direct short affidavits.
My lord.
Cannot be decided without affidavits, this matter. They may have something to say, Tata Motors.
Yes, my lord.
I'll direct short time to file affidavits.
Yes, my lord.
The petitioner has made out a prima facie case as to the respondent number 3, Tata Motors, having not served any prior notice before seizing the petitioner's vehicle on the allegation that the petitioner has apparently failed to repay certain installments of a loan between the petitioner and the respondent number 3. Full stop, next para. In order to ascertain the stand of the respondent number 3, the respondents are directed to file their affidavits in opposition within 3 weeks from date. Full stop. Reply, if any, shall be filed within 1 week thereafter. The matter shall be listed on July 17, 2023. Full stop. The respondent number 3 shall not deal with the vehicle in question, shall not further deal with the vehicle till July 31, 2023 or until further order, whichever is earlier.
Next matter is same matter.
Also Tata Motor.
Same matter, same.
Seven টা
Item
board এ
number
দেখাতে
same.
বলবে। 7 also then similar order.
This is my video service.
Good.
I'm grateful, madam. Thanks.
Two vehicles.
Two vehicles, sir. Two is different vehicle. One 12 lakh and 22 lakhs.
Very good.
Grateful, madam.
No.
Item 8.
But I applied for the petition, my lord. Here I have a challenge
for the
provisional assessment order, my lord, which was my lord, issued on 7th February 2023, my lord. Till date, my lord, final assessment has not been served, my lord. I have made an application for raising objection, my lord. My lord, in the provisional assessment, it has been stated that it has been classified that the electricity line as agricultural, my lord. That is for energizing the, my lord, submersible pump, my lord. My lord, I have no, my lord, the submersible pump, my lord, and I have
no submersible pump.
And I have been residing with my elder brother at my lord Gujarat, my lord. I do not reside here, my lord. I'm not residing here, my lord. Despite that, this provisional assessment issued, my lord. And in terms of section 126 provides, my lord, within 1 month, my lord, from the
yes, please, Dr. Sahara. 1 month.
Already final order of assessment has been passed, but their representative refused to accept that. I have got that copy.
Refused to accept the notice.
Refused to accept the hearing notice as well as final order of assessment. Final order of assessment was passed on 6th of March 2023.
Can you hand over a copy?
Yes,
to
yes,
them?
certainly.
No, you have two options. Unnecessarily, I think the first option is a non-option. Directing affidavits does not mean anything. Since you know this, I'll record this. I'll record your challenge, record this, give you leave. Learned counsel for the petitioner submits that despite the specific mandate of section 126 of the Electricity Act 2003, the respondent licensee, after raising a provisional assessment order, failed to serve any copy of final assessment to the petitioner. First up, the petitioner has already applied to the WBACDCL for being given a hearing on the provisional assessment, but in vain. Full stop. Next para. Learned counsel appearing for the WBACDCL controverts such allegation and submits that not only was a notice of hearing on the provisional order of assessment sought to be given to the petitioner duly, a similar notice was also sought to be given of the final order of assessment, which has been subsequently passed in due process of law. Full stop. However, on both instances, the representative of the writ petitioner refused to accept such notice. Full stop. Hence, there is no irregularity on the part of the WBACDCL. Full stop. Next, be that as it may, since a copy of the final order of assessment is also handed over in court today by learned counsel for the WBACDCL to his counterpart appearing for the petitioner, the remedy before the petitioner now is to prefer a challenge before the same in due process of law. Full stop. Accordingly, WPA 13178 of 2023 is disposed of by granting the petitioner liberty to challenge the final order of assessment passed against the petitioner before the appropriate appellate authority under section 127 of the 2003 Act. Full stop. It is made clear that in view of the pendency of the writ petition, the period elapsed in pendency of the present writ petition shall be deemed to be deducted from the limitation period for preferring such appeal.
DPO.
I appear for the state in this matter.
Very well. Just আর এটাতে একটা লাইন অ্যাড করে দিও তন্ময় এফিডেভিট অফ সার্ভিস।
Item 9.
My lord, I am appearing for Advocate Firdos Shamim. I am praying for not
Move the matter. Why are you taking time? What is the matter about? Move the matter. Yes. Move the matter. Start the matter.
I am not well versed with the brief, my
Very.
lord.
On the prayer of the petitioner, the matter is adjourned for the day.
Grateful, my lord.
Parted.
Item 10.
My lord,
এবার থেকে না যেগুলো adjourned for the day হয়ে যাচ্ছে
in this-
specific না
my lord,
ফিক্স করি তাহলে তলায় পাঠাও কিছু করার নেই
Well,
Yes.
In this case, service is not yet complete. And that's why.
Learned counsel for the petitioner submits that you are not for the respondent, I
No,
hope.
I'm for the petitioner.
Learned counsel for the petition.
Tuesday. It will be served.
Not Tuesday. I'll make it not today. It goes down.
Okay.
You're so happy. Learned counsel for the petitioner submits that service has not yet been completed. Accordingly, let the matter stand adjourned for the day. এগুলো তলায় পাঠাবে যদি না স্পেসিফিক কালকে রাখি মানে পরের দিন রাখি দেখো
Item 11.
My lord, I'm for the respondent bank.
Respondent not suffering any interim order.
Not suffering in any.
None appears for the petitioner, although the respondents are represented through counsel. Let the matter stand adjourned for the day. Yes. Next.
Item 12.
WBCTL code. I am for the state. But
State.
In this matter, I am appearing for the
The all the respondents have been served.
Yes, Lordship. This is a
Right.
respondent school, Lordship. In this matter, I am challenging I am praying before your Lordship to change the surname of my son's surname.
12.
13. 12 টা তো হয়ে গেল।
না 12 হলো না তো 11 হলো।
This is Rima Shaha.
Oh, Lordship, 12. I am 13.
12 এ কেউ দাঁড়াচ্ছে না তো ভাই।
None appears for the petitioner, although the state is represented through counsel. Let the matter stand adjourned for the day.
এবারে তো
Sorry, sir. Sorry.
Stated হয়ে সুমন ঘোষ corporate.
Item 13.
You are for the petitioner, good service affected. So you are wanting change of your surname.
Surname.
What is the context?
My son's surname.
Son's
Surname.
son is a minor.
Yes, Lordship. He is a student of class 9.
Acha, why?
He, after divorce, he is staying with her mother, and his mother, if do first class, kindly come to page 24, change the name of his surname before the first class judicial magistrate, and thereafter.
But fatherhood remains. Undoubtedly, after divorce, your ties are severed. But your ex-husband still remains the father.
He is not taken any responsibility.
That
And
I
he-
fully appreciate. I mean, obviously.
She also change the name. Aadhaar card surname also change. Kindly come to page 28.
Is the ex-husband a party to the writ petition?
Yes, Lordship.
Please check up whether good service has been effected on him.
সার্ভিসটা যে রিসিভ করেছে সেটা কি করে বুঝবো? ইয়ে কোথায়? রিসিভ করেছে? ট্র্যাক রিপোর্ট তো নেই। ট্র্যাক রিপোর্ট রিসিভ করেছে?
Do you have a copy of the divorce decree?
Yes, Lordship. Kindly come to page.
No rights were given to your husband, custody or anything like that?
Nothing.
Nothing
Nothing.
was-
Lordship. Problem is this, son is student of class 9. It was next year.
Everything in everything. Is.
And Aadhaar card is also changed the surname.
Despite service, none appears for the respondents. Full stop. Affidavit of service filed today be kept on record. Full stop. The petitioner is the mother of a minor son who is studying in class 9 of a particular school. Full stop.
Page 90, I served the representation was received by the school, but school is not.
Writ petition is maintainable then. Writ petition is not maintainable.
My lordship.
How can you maintain the writ petition? School is a private school.
No, lordship. School is not a private school.
Have you stated anywhere? অনেকগুলো ঝামেলা রয়েছে।
Principal of Barashat Indira Gandhi Memorial High School, lordship. This is not a private school, lordship.
Is it government? Have you stated anywhere government aided or something? Otherwise, writ is not maintainable. No. বসুক তো।
Lordship, kindly come to page 9. Lordship, this is not a.
Page 9.
Page, paragraph 9, lordship.
Yes.
Page 4, paragraph 9.
Yes. No, the rest of it I can appreciate, but
But this is not a aided school. This is a government school, lordship.
how do I know it has? You have never stated anywhere.
Lordship, this is petition is not.
Nothing is stated.
written- Yes, lordship. Petition is not written by me, lordship.
Obviously.
Difficulty. But this is not a aided school. This is a government school, lordship.
Should I record? But something should be on record. Well, file a supplementary affidavit. I'll keep it as to be mentioned on Tuesday.
Lordship.
Can you do that within that?
Yes, within.
Affidavit of service filed to be kept on record. Full stop. Despite service, none appears for the respondents. Full stop. The innocuous prayer of the petitioner, who is the mother of a minor son studying in class 9 of a particular school, which the petitioner claims to be a government school, is that after obtaining divorce from her husband, the petitioner is facing several difficulties in pursuing with the educational career of her son due to the surname of the son still remaining in the school records as what was the name of your husband? The title of your Ghoshal.
Lordship, kindly.
Ghoshal.
Ghoshal, lordship.
Ghoshal.
Ghoshal. Ovijit Ghoshal.
Still Ghoshal. Full stop. Next para. It is thus submitted that the petitioner and her minor son be permitted to change their surnames to Bhattacharya, which is the maiden surname of the petitioner. Full stop. Next para. However, there is no specific averment in the writ petition with regard to the school in question being a government or government aided school. Full stop. Accordingly, the petitioner is directed to file a supplementary affidavit disclosing whether the school is a government or a government aided school. Full stop. Such affidavit shall be filed on June 20, 2023, when the matter shall be listed under the heading to be mentioned for passing orders.
Lordship.
Thank you. No, ঠিক আছে।
Item 14.
14, my lord, I am appealing for the petitioner.
Yes, Mr. Chatterjee, good service.
My lord, the railways, my lord, one of the executive officer, my lord, has refused. That is apart from the
Good
track
service.
report. But my lord, there are other persons in the railways who are made parties. My lord, to that extent, the service is not satisfactory. Now, my lord, be that as it may, my lord, the
What is the matter? Yes.
issue here is, my lord, I am challenging the authority of the certificate officer to proceed against me. My lord, what happened, my lord, the railways, my lord, in its contract, in its capacity, entered into a private contract between me and the railways. My lord, for my lord, advertising in railway premises. My lord, the agreement was terminated, my lord, on certain grounds. My lord, we also, my lord, oh, my lord, we also, my lord, in later, my lord, raised a dispute, my lord, with respect to that you have not provided electricity. We could not display our boards. My lord, area was not up to the mark, which was detailed in the, my lord, agreement for contract. My lord, despite that, my lord, they demanded a license fee. My lord, and my lord, terminated the contract and the license fee was fell due. Now, my lord, after that, my lord, there, I would say, my lord, if kindly turns to the, my lord, letter to that, kindly turns to page 85 for once.
Yes, 85.
85. My lord, the relevant part is, my lord, at the bottom page 86, you are also requested to pay. So, my lord, in event if I do not pay, they will take appropriate legal action.
What is that requested to pay? Page
Page 86, the kindly turns over. You are requested to pay the railway dues amounting to such and such through demand draft, such and such. Otherwise, legal action will be initiated. Now, my lord, this, my lord, legal action, my lord, is entrusted in the agreement and arbitration clause is there. My lord, they do not initiate the arbitration clause. My lord knows the arbitration clause. My lord, they have the authority as per their contract to initiate their, appoint their arbitrator. My lord, they do not do that. What they do, they immediately place this termination letter. I would say this is not a demand also, this is a termination letter. My lord, to the certificate officer. My lord, under the Public Demands Recovery Act. The certificate officer, my lord, takes note of this and my lord issues notice against me. My lord, I approach the certificate officer and say this is not maintainable, this is not a public demand. My lord, and because you have to be a public demand, it has to fall under Schedule 1. My lord, what the certificate officer does is, my lord, kindly takes the order, my lord, the page 88. My lord, the from bottom the sixth tick.
Yes.
Anyways, one line. Anyways, the petition is rejected. Let it be tried in the appellate forum. Appropriate forum. Now, my lord, he do not go into his authority to decide its authority, whether it's a public demand or not. Now, my lord, and fixes
This is a certificate authority.
My lord.
Which is the certificate authority?
Certificate authority, my lord. This is Rule 120 record manual and the proceeding.
So you are asking for what interim relief?
Well, at least he keeps this on 28.6. He constantly says that you have to make payment, otherwise, my lord, arrest warrant, which are the penal consequence will come.
I'll stay the proceedings, further proceedings of this, but permit them to proceed in accordance with law with their legal action.
Yes, yes. If they take initiate arbitration, even I have invoked.
I'll just keep it as at legal action. I'll record your submission.
Yes, that says this proceeding, my lord. Otherwise, my lord.
Very good. Learned despite service, none appears for the respondent authorities, respondents, full stop. It is fairly submitted by learned counsel for the petitioner that one of the officers of the railways has refused the service, full stop, insofar as the others are concerned, comma, service has not yet been completed. Full stop, however, comma, in view of refusal being deemed to be a good service, comma, it is deemed that the estate of the interest of the respondents are sufficiently represented by due service by way of refusal. Full stop, next para. The grievance of the petitioner is that a contract between the petitioner and the respondent authorities was terminated, and subsequently the respondent authorities gave a letter to the petitioner on June 20, 2016, whereby a request was made to pay alleged railway dues amounting to the tune of rupees 10,28,580 along with late fine through demand draft / pay order. Full stop, next para. It was further warned, WRNED, in the said communication that if the petitioner failed to pay such amount, comma, legal action would be initiated. Full stop, next para. However, without taking any due legal recourse, the respondent authorities directly treated the said claim of the respondent authorities as a public demand, and a notice of demand was issued. Full stop. When the petitioner approached the certificate authority for stay of the proceedings, the same was refused. Full stop.
My lord,
But
only subject to correction, we
you did
made an
not pre-
application saying that there is no public demand, it is not maintainable.
আচ্ছা, very well. When the petitioners, আমি বললাম যে prayed for stay বললাম কি? Prayed for stay টা কেটে দিয়ে challenge the maintainability of the proceeding, the certificate officer refused to entertain such prayer and proceeded with the certificate proceedings. Full stop. Next para. It is contended that such initiation of a certificate proceeding deeming the claim of the respondent authorities automatically as a public demand is palpably dehorates the law and vitiated by arbitrariness. Full stop. Next para. There is sufficient strength in the prima facie case made out by the petitioner on such score. Full stop. Accordingly, the writ petition is required to be heard on its merits. The respondents are, thus, directed to file their affidavits in opposition within 3 weeks from date. Reply, if any, shall be filed within 1 week thereafter. The matter shall be listed for hearing in the monthly list of August 2023. Full stop. All further proceedings
In proceeding number 14 stroke miss
in
case
proceeding
18
number 14 stroke miscellaneous MISC
stroke 18
stroke 18 na 14 stroke miss of 2018 pending before the which authority?
Lord, this is the certificate officer.
Pending before respondent
South
number
24
4.
Pargana.
Respondent number 4, that is the certificate officer, South 24 Parganas, shall remain stayed till September 15, 2023, or until further order, whichever is earlier. Full stop. It is made clear that the above interim order shall not preclude the respondent authorities from initiating appropriate proceedings in due process of law for recovery of their claim, if the respondents are otherwise entitled to do so in law, even during the subsistence of the said interim order.
The next matter is same between the same parties, as there were two contracts. Another proceeding was
So same order then.
Same order, the proceeding number would change.
Proceeding number take to
Brief
14 or 13?
13. 13. That the next is 13. Miss case.
Next is 13.
Yes.
Very good. अब যা আছে যায় 14 এর জায়গায় 13.
And the amount will change.
Oh, amount will change also. 13 করে দাও, মিস কেসটা 14 এর জায়গায় 13 হবে.
Amount of
Please write down the amount in a slip of paper and also miss case number 13 and just hand over to her. Thank you. Next, the same order. I'll take up the next matter after 10 minutes.
আমাদের কত
Me, please, Lordship, I am.
Lord, I have the CS in this.
Right.
My Lord, this is an application for new connection. After the application, the ESC authority made inspection. Thereafter, my Lord, kindly see the annexure B3, page 13, new connection, my Lord, kindly see page 13, annexure P3,
Yes.
second stanza, as the site inspection has been completed, and to enable us to proceed further in this matter, we are requesting to furnish your registered deed in your favor at the list. Petitioner is the owner of the premises after demise of his parents.
Then produce your deed.
Then,
Then produce your deed.
my lord,
Others
we have-
deed or
we have-
whatever
We
is.
have produced, my lord, kindly see the annexure P4, page 14. We have produced. And now they inform us, annexure P5, page 15, there is outstanding dues in the tune of 65,036. That is page 15, middle portion. Renuka Chatterjee, Srimati Renuka Chatterjee. My lord, what is the matter is earlier.
What is the name of Renuka Chatterjee?
She is the mother.
Where is that name? Page 15.
Middle, consumer name.
Oh, acha.
LCC reference.
Oh, I'm sorry.
consumer
Yes,
number,
yes.
consumer.
So your mother.
Yes, I'm coming, Mal. Before that, Renuka Chatterjee's line has been disconnected by the CSC authority on the alleged ground of pilferage.
Oh, pilferage.
Against that, son being filed a writ petition, and there is order, Mal, page 16, annexure P6. Mal, kindly see the order.
Yes.
And the ordering portion, my lord, they will, if applied for, the CSC authority will change the name. Not only that, final order has been set aside, rehearing order has been, well, kindly see the order, entire order, it will be clear from this petition. They have not changed my name till today. Next page. Next, as per order, I paid 71,000, that is annexure P7, page 18. As per order of the division bench. No, single bench. And my lord, annexure P8, page 19 is my application for.
Division bench said that on payment of you deposit 70,000. If you deposit 70,000 without prejudice to the rights, as an interim measure, why interim measure? What was kept pending?
The rest of the amount.
Yes.
My lord, I'm coming. My lord,
Why interim measure? Because this was
my
the
lord,
writ petition
yes,
was disposed
the
of.
order, it has been the reheard the fire.
For that.
That is the, and after that said order, CSC has not called any hearing till today. Now they are demanding in order to give me the connection, fresh connection. They cannot, my lord. That is our job.
Yes, Mr.
And the name change have
Not been affected. Not been affected. Name change has not been affected.
I have page 19, annexure P8, application they have received. Till that they have not changed the name. এবার আপনার বলার সময় বলুন।
Milord, on February 2023,
yes,
the unauthorized use was detected. And upon hearing the parties, an amount of rupees 1,35,036 was finally assessed. The petitioner moved before the Honorable Court, Milord, and may I read out the order for once. Milord, from the admitted position is that the meter is lying in the.
That has been annexed here.
Yes,
Milord, page 16. Kindly comes to page 16.
Oh, this one, yes.
Order.
Yes. Admitted position.
Admitted position is that the meter is lying in the name of the deceased mother of the petitioner who passed on so and so date. Let the assessing authority rehear the petitioner upon giving the petitioner prior notice of hearing. The petitioner shall complete the formalities for change of name of the consumer within a period of 2 weeks. In the event no such step is taken, then appropriate action initiated by the electricity company. The impugned final order of assessment is quashed in these peculiar circumstances of this case, and the matter is directed to be heard again. Yes. It was contended of CSC Limited that service was sought to be affected on the registered consumer, but the same was refused. Registered consumer was the mother of the petitioner. However, since the notice is alleged to have been sent by the private courier service, in the absence of the specific affidavit from the, this is not that much relevant. Next page, In the event the petitioner deposits 70,000 without prejudice to the right and contentions of the parties as an interim measure, supply shall be restored only after the petitioner takes necessary steps for change of the name of the consumer. May I repeat, my lord? Supply shall be restored only after the petitioner takes necessary steps for change of the name of the consumer. Restoration shall be effected in the name of the petitioner provisionally only, but he files the requisite forms and complies with the other requirements within a period of 2 working days. My lord, subsequent to the deposition of 70,000 on 13/8/2023, the connection was restored. Till date, my lord, the petitioner only except obtaining a docket number has never approached us, has not complied with any of the formalities, my lord, and as on date, since he is not a consumer, name has not been changed, the question of rehearing also doesn't appear.
No, the petitioner did not complete the formalities for change.
Nothing except obtaining a docket number. He has
Who was a docket number obtained?
My lord,
They applied for change of name.
yes, only the docket number was obtained, and thereafter he is supposed to.
What is the significance of docket number? Docket is obtaining.
The docket number is
Even if I complain over the
acceptance
phone, docket number is.
that only he has applied, and we have accepted his request. Nothing else.
But no,
Yes.
my learned friend
So let him finish, Mr.
And
Halder.
presently, he is enjoying the supply from the meter in the name of his mother.
Obviously.
Unless there is a clear nexus between the son and the mother. Outstanding dues are amounting to rupees 65,000 and 35 rupees. So, my lord, unless that outstanding is paid, the said meter cannot be removed or a new meter cannot be installed.
No, as per Justice Bose's order, they had to apply for complete the formalities for change of name within 2 weeks. In
Yeah,
the
that has
event
not been
such
done.
step is
we
taken,
have done.
Nothing has been
That
done.
is
No
annexed.
payment has been made. Nothing has been done.
Well, they have not communicated anything after this docket number. What is docket number? My learned friend is well aware of that. Docket number is whenever we give certain things to the CSC authority.
That is
they-
only a formal
আমাদের
receipt.
বলছে যে,
Mr. Ghosh, please take your seat. I'll just hear Mr. Halder.
whenever we made some offices.
Yes, Mr. Halder, show me that you applied for electricity change of name.
Well, Annexure P8, page 19.
There is an acknowledgement slip.
Acknowledgement is a receipt. Receipt of application is acknowledgement slip.
You say after this they did not do anything.
They have not called me. They have not taken any step. Not only the Mala, can you see the order of Mala Justice Bose? Order is very much 70,000 plus I have to give him. I have to give, we have paid. We applied for change of name. And there is the order of final assessment has been set aside quas. And rehearing will be held. But till today, they have not called for rehearing of the matter. As such, that dues cannot be accrued on.
Mr. Ghosh, here what has happened, Justice Bose directed specifically that if they comply, if they take steps.
We have restored the connection on.
You have restored the connection?
Now, my lord, unless he is a consumer, by changing the name, the question of rehearing.
So for that,
doesn't
after
arise.
making that application, that has to be processed by you.
Yes.
My lord, he has only submitted this number. Thereafter, they have been contacted to come over and comply with the formalities. Unless the formalities for changing of the name is done. my
What
lord.
formalities?
Because may not have.
You have to inform them what.
Payment, that we will do in the meantime.
If you have not done that, you cannot say.
We have done it. The letters are here with me. Unless the name is changed, question of rehearing
You have to change the name. They have applied already. After that, what can they do?
Milord, they have to approach us, they have to make
They
the
don't have to
interim
approach.
payments.
They have made their application. After that, you have to give them estimates or whatever. You have to inform them what to do.
Estimates, I think,
They have made their application.
Milord, estimates, I think, have been already given to them.
Then I'll direct you to file affidavit, to disclose all the documents. In the meantime, don't disconnect on the basis of this prior.
No, they are already enjoying electricity.
No, my landed, my landed.
And Milord, only one thing, only one.
Both of you cannot argue together, Mr. Haldar.
Hold on.
Mr. Ghosh, you finish, then I'll hear Mr. Haldar and end it.
Milord, the question of rehearing is concerning the final assessment amount.
Yes.
So, Milord, unless he is a consumer, we cannot call him for the rehearing. So, Milord, let him approach us, or we will approach him and let
But
him.
do you say,
complete
Mr. Ghosh, that after they apply for this change of name, unless they deposit the outstanding dues,
change of
change
name
cannot be
cannot be
effected.
done. So once the change is done, Milord, then comes the question of rehearing and final assessment amount. What is to be paid?
And my lord, kindly see what is the order?
And as on date, he is enjoying the
No,
connection.
Mr. Haldar, let us see the order once again. Let us come to page 16.
Page 16.
You shall, the petitioner shall complete the formalities for change of name. You have completed.
Yes.
In the event no such step is taken, appropriate
Then-
action,
then-
you have
then-
taken the step.
Yes, yes.
The impugned final order of assessment quashed, rehearing directed.
No hearing has
Yes.
been made. They have not preferred an appeal or challenged this
Yes.
order.
Supply shall be restored only after the petitioner takes necessary steps for change of name. So you have applied, taken steps, they have restored also. Restoration shall be effected in the name of the petitioner provisionally after he files requisite forms and complies with other requirements. Now, restoration has been given. Your
My-
only
no,
grievance
no,
is
no,
restoration has been given to you.
No,
Provision-
my lord, slightly different. Restoration in the name of dead person.
Mr. Haldar, that was the
Yes,
specific
yes,
direction.
yes,
No,
yes.
that was the specific direction.
That was in the, that
Supply shall be restored only after you take necessary steps for change of name, not in your name. Unless you pay the outstanding dues, why should the change of name be effected?
one more, my lord, kindly
No.
see. This is a fresh
Mr.
application.
Ghosh, give them a hearing,
My lord,
hear them. I'll get stipulate the time limit within that, then decide the issue of outstanding, and after that,
my lord.
My lord.
learned counsel for the petitioner argues that there was a previous round of litigation when the distribution licensee, that is the CSC Limited, claimed outstanding dues from the mother of the petitioner, who was the erstwhile consumer in respect of the disputed electricity meter, on the ground of unauthorized use of electricity. Next para, the petitioner moved court, upon which a coordinate bench with a order dated August 8, 2013, passed in WP number 21685 within bracket W of 2013, had quashed the provisional order of quashed the final order of assessment in the peculiar circumstances of the case, and directed the directed the concerned authorities to hear the matter again. Full stop. In the meantime, the the electricity supply in question regarding the defaulting meter was directed to be restored, subject to the petitioner completing the formalities for change of name of the consumer within 2 weeks therefrom. Full stop. Next para. It was further observed by the learned single judge that in the event the petitioner deposits ₹70,000 without prejudice to the rights and contentions of the parties as an interim measure, supply shall be restored only after the petitioner takes necessary steps for change of the name of consumer. Full stop. Restoration, it was directed, would be effected in the name of the petitioner provisionally only after he files the requisite forms and complies with the other requirements within a period of 2 working days. So it is argued that the petitioner duly deposited ₹70,000 and undertook all formalities for the purpose of change of name. Full stop. However, neither any hearing was given to the petitioner for a final regarding the direction of the learned single judge to give a fresh hearing, comma, nor was the restoration effected in the name of the petitioner, comma, either provisionally or otherwise. Full stop. Next para, learned counsel for the CAC Limited submits that upon the deposit of 70,000 and an application being made by the petitioner for change of name, comma, the connection was given on an interim basis in compliance with the order dated August 8, 2013. Full stop. However, comma, for the change of name in the records, comma, the petitioner is required under the relevant provisions of law to deposit all pending outstanding dues. Full stop. Unless the outstanding dues are
No, my lord, may I interrupt me? Outstanding dues will be decided subject to the rehearing. And
obviously,
rehearing, and my lord, the
যা বলেছি এখান থেকে কন্টিনিউ করি, আই এম অন দ্য রাইট ট্র্যাক। কি বললাম, কোনখানটা ছাড়ুন? Decided afresh, comma, upon a rehearing being given, comma, the question of such payment or the change of name does not arise. Full stop. Next para. It transpires that an interim restoration was effected by the CAC Limited in terms of the order of the coordinate bench dated August 8, 2013, comma, upon the petitioner having applied for the change of name duly and having deposited rupees 70,000 provisionally. Full stop. Next para. However, comma, there is nothing on record to indicate that any rehearing has yet been given to the petitioner as per direction of the coordinate bench. Full stop. In such view of the matter, insofar as the change of name is concerned, comma, since the supply to the disputed electricity meter has been restored and the petitioner is enjoying the electricity from the same in an unhindered manner, comma, it cannot be said that the direction as to provisional restoration was not complied with by the CAC Limited. Full stop. Next para. In the circumstances above, comma, WPA 13862 of 2023 is disposed of by directing the CAC Limited to notify a date of rehearing to the petitioner, comma, for the purpose of compliance with the order dated August 8, 2013, passed in WP number 21685 within bracket W of 2013, and, comma, thereafter, comma, upon giving an opportunity of hearing to the petitioner, comma, decide the issue of final assessment on the allegation of unauthorized use of electricity afresh. Full stop. The entire exercise shall be completed by the CAC Limited as expeditiously as possible, comma, positively within 6 weeks from date. Full stop. Next para.
My lord, kindly permit me to submit one.
No, sir. Yes.
My lord, the restoration, the consumer as on date is the mother of the petitioner who has expired long back.
Yes.
And
if there is no change of name, obviously.
My lord, rehearing can only come after the change of name. So, my lord, we cannot give him the rehearing unless the change of name.
Unless the rehearing is given, unless the change of name is effected, you cannot give rehearing. And unless the rehearing is held, you cannot assess the outstanding. So it will never be done.
No, my lord.
That is your argument.
What I want to submit is that unless there is the change of name, should come first. Thereafter, the question of rehearing, and thereafter, the question of finalizing.
So at present, they have deposited 70,000. Effect the change of name.
My lord, but this 70,000 has been paid only for restoration of the supply, not for the change of name.
What will have to be done by them for the change? They'll have to pay the entire disputed amount.
No, absolutely not.
What is your submission, Mr.? What are you submitting?
I am not submitting that. And because he is not a consumer as on date, unless he is a consumer, my lord, we cannot conduct the rehearing. And he can only be the consumer once the name is changed in the name of
Then change his name tomorrow.
subject to compliance.
What compliance?
For changing name, they have to pay certain amount as directed under the law. So
Not the outstanding amount.
no.
Actually, they're ready to pay.
Absolutely not. This is the only submission I need to pay, that the change of name should come first. He will become the consumer. Thereafter comes the re-hearing, and thereafter assessment final amount.
আসুন যেখানে ছেড়েছি সেখান থেকে শুরু করুন হ্যাঁ 6 weeks from date হ্যাঁ full stop next para. However, comma, it is made clear that the CSC Limited shall, comma, by tomorrow, comma, intimate the petitioner directly or through the learned advocates for the petitioner in this court, comma, as regards exactly what further formalities have to be complied with by the petitioner for effecting the change of name of consumer in the name of the petitioner. Full stop. Upon such communication, upon such intimation being given, comma, the petitioner shall, comma, by June 20, 2023, that is next Tuesday, comma, comply with all such formalities. Full stop. Upon the compliance of such formalities, comma, the above order, above direction regarding a date of hearing being fixed and a rehearing being done on the final order of assessment shall be carried out. Full stop. It is, comma, however, comma, made clear that the change of name which shall be effected by the CSC Limited upon the petitioner complying with the formalities by June 20, comma, shall be carried out positively by June 22, 2023. Full stop. Next para. It is further clarified that, comma, for the purpose of such change of name, comma, the within double inverted formalities, double inverted clause referred to by the CSC Limited shall not include the payment of any outstanding dues by the petitioner on account of the alleged unauthorized construction, comma, which will only be decided subsequently after the rehearing is given to the petitioner.
Grateful, my.
Thank you.
My lord,
No rest to cause urgency.
my lord, I was
Parties shall act on the server copy.
my lord, I was not
Yes, sir.
allowed to, because my lord is passing order. My lord, case is little bit different. It will be, the order will be defective on that. My lord, petitioner applied for new electric connection, and as per inspection, we have submitted all formalities.
Have you applied for change of name?
Yes, we have done that in the previous meeting.
That will be carried out. Why new connection? What is the question of new connection?
My lord, if it is carried out, then
Yes, change of name will suffice.
my lord,
Either you take new connection or change of name, both cannot go on together.
no.
That
We are
is the
not
specific order of the coordinate bench.
My lord, please be-
Item 17.
Yes, 17 is appearing. You are for the petitioner. Yes, what is the matter?
This is a matter on a loan. I took loan admittedly 49 lakhs. And my lord, 15 I have paid.
Good service has been effected on
My lord,
all the
the authorized officer has been served.
Yes. You took a loan of 49 lakh.
Yes.
Then?
We are ready to pay the, my lord, we have already paid 15 lakhs. They are now claiming 76 lakhs. We are saying that reduce some interest, we shall pay at a time. This is the whole issue.
Then pay it.
No, but in the meantime, my lord, kindly look at, this is the crux of the problem. Page 30, they have taken possession. On the one hand, they have taken possession asking that you pay. We are saying that we are ready to pay, but the
Why did you file the writ for that? Pay the amount, get the
some
property
reduction-
released.
Some reduction we are praying for.
Reduction, can the writ court give?
Now it has been, they are asking one for about 80 lakhs.
This was meant for some different court.
No.
Reduction writ court can.
77 lakhs.
I don't have the authority to give to reduce somebody else's loan.
No, my lord, kindly direct them to, my lord, we have already requested by my letter.
So I'll direct them to consider your letter.
Yes, and we shall pay at a time.
Now, I will not direct that. Pay at a time. If you want to pay.
No, at a time, but 2 or 3 installments. If about, my lord, 70 lakhs or 80 lakhs,
There is a scope of relief in this.
My lord.
No scope of relief in this writ
Yes,
petition.
yes, I know that. My lord, my lord, we shall negotiate. Or they have also asked that you contact with such and such.
Very well. Despite such,
But in the meantime, the property should not be encumbered further.
I'll limit the time.
Yes.
Learned counsel for the
And,
petition.
if possible, reduction of some interest. That we have prayed.
Despite service, none appears for the respondents. Full stop. Affidavit of service filed today be kept on record. Full stop. The innocuous prayer of the petitioner is that admittedly the petitioner took a loan of about rupees 49 lakh, which the petitioner now wants to repay. Full stop. However, comma, in view of certain financial difficulties, comma, the petitioners pray that the amount of interest payable thereon be reduced. Full stop. The petitioners wrote in that regard on June 8, 2023 to the authorized officer
Page 31,
of
May
the
23.
Tata Capital Housing Finance Limited, which is the respondent number 1, comma, a copy of which is annexed as annexure P7 at page 37.
P5 is, my lord, more.
5.
P5, yes, yes. Same prayer, P5.
Very well.
May
Is
20.
annexed as P5 at page 31.
31 to 33.
না না যেটা বলছিলাম সেখানে P7 at page 37 of the writ petition, full stop. Similar representations were also given by the petitioners on earlier dates, comma, which are also annexed to the writ petition. Full stop. Next para. It is submitted that the respondent authorities be directed to consider the said representations sympathetically and release the property of the petitioner, comma, the possession of which has been already taken. Full stop. Next para. However, comma, the writ court does not, comma, as such, comma, has the liberty to show mercy on behalf of others. Full stop. Next para. Yet, comma, since the petitioners have shown their bona fides in being willing to pay the entire amount of debts and have merely sought a reduction in the interest, comma, WPA 13866 of 2023 is disposed of by directing the respondent authorities to consider the representations of the petitioners as annexed at page as annexed to the present writ petition on in a sympathetic light, and to decide on the same as expeditiously as possible, comma, positively within 3 weeks from the date of communication of this order to the said respondents. Full stop. The parties shall act on a server copy of this order. Full stop. The petitioner shall serve a server copy of the order to the respondents as expeditiously as possible, comma, positively within a week from date. Full stop. The respondent authorities shall not deal with further the property in dispute, comma, which has been taken possession of by the respondents, comma, till July 15, 2023, till July 15, 2023, or until a decision is taken on the representations of the petitioners, comma, whichever is earlier.
My client, if it is 50 lakhs, he will pay on.
I think it is better that you pay early so that this can be resolved.
No,
No rest.
77. He is asking for some reduction. He will pay at a time. I am extremely grateful. Man.
Communicate immediately, please.
Yes, yes, yes. It is Park Street area, no problem. Yeah, I am grateful.
Yes.
18,
Wait, please, your lordship, my lord.
Yes.
Lord, this is concerning the election of an apartment
Respondent number 3.
registered under the West Bengal Apartment Ownership Act. Lord, I tell you, lordship, my lord, the Apartment Ownership Act 1972, the bylaws have been amended in April 2022. Now there is a bylaw of 2022, which says that every 3 years there will be an election in the month of May, and the mode of election shall be decided by the members in a special general meeting. Now, here in this case, the mode of election was decided, my lord, online, that there will be online voting. There were disputes with regard to whether online voting could be taken place or not. Your Lordship's court, the coordinate bench has ruled in the South City case that online voting is permitted. So online voting, everybody agreed. Now the outgoing board, they appointed, I have made the returning officer also a returning officer, and CDSL, Central Depository Services Limited, who are normally conducting this sort of elections, they were appointed to conduct the elections on their platform. Now, after the elections was conducted on 28th of May, the board is required to be constituted by 31st of May, because the elections to be held by the end of May. The scrutinizer filed a report saying that the petitioners who are before your Lordships and others, they have succeeded in the election. The bylaw says there has to be 48 members of board. If the 1/3 members elected, the returning officer, give showing some reasons, has said that the election is null and void. Now, the competent authority and the returning officer, what he did, he directed the erstwhile board to refer the matter to competent authority. The competent authority took it upon himself. He says that I have no power to go into the dispute, by I appoint an administrator in the
What is that?
Kindly come to the implement order, page 120. Rich. My lord, may not trouble your lordship with the first page, take 121. It is evident, last paragraph, from the record that there is no board of managers to run the, is not the first paragraph. The competent authority under the West Bengal Apartment Ownership Act is a statutory body. All powers and functions and duties flow from the West Bengal Apartment Ownership Act and rules. Apartment Ownership Act or rules framed thereunder have not conferred upon him any power to adjudicate disputed fact, let alone election disputes. Having recorded that, he has recorded the last paragraph. It is evident from the record that there is no board of managers to run the association from 1st June. This authority is of the opinion that non-existence of the board of managers is detrimental to the interest of the association and the apartment owners of that housing complex. It is also against the public interest in view of the facts stated therein before the authority in excess of powers conferred under section 16B of the Act, hereby appoint Mrs. Meghna Paul, Administrative Officer in Newtown, Kolkata Development Authority, as the administrator to perform the functions. But 16B, if my lord takes the Act, that's the only power of the competent authority. But 16B has two parts, 1 and 2. My lord, got it, not? 1. If the association of the apartment owners having right to be exercised by the managers or the board of managers fails to perform its functions under this act or bylaws made thereunder, the competent authority may give to it such direction as the authority confers fit. So if there's a failure, then if the competent authority is of the opinion that the function of the managers of the board of managers is detrimental to the interest of the association of the apartment owners or of the apartment owners or is against the public interest, the competent authority may give a notice to the managers or the board of managers to show cause why he should not be removed, or as the case may be, it should not be superseded. If the reply of the managers of the board of managers is not considered satisfactory, the competent authority may by order remove the manager or supersede the board as the case may be and appoint any member from amongst the members of the concerned association or of apartment owners or any employee of the state government or any other person as the administrator to perform the functions of the managers or the board of managers as the case may be. So this is the power of supersession or removal. So when there is an existing board which fails to perform some duty, the competent authority.
You are a part of the erstwhile board.
No.
I am there for the erstwhile board, my lord.
So if at all, then according to you, then the erstwhile board has to continue.
No, Lord, I have two limbs of submission. Firstly, that he has exercised jurisdiction without having any authority.
Suppose I set it aside.
Now, my second limb of argument is, I am not inviting your lordships to decide whether the election is rightly held or wrongly held.
No.
Lord, today the situation is an election is held. the returning officer who was appointed by them, I'll show the document, has said that the election is null and void. My lord, the mode was decided unanimously. My lord, I am saying that my lord kindly appoint an officer of your lordship's court.
So the null and void order, have you challenged that?
Yes,
also?
he's under challenge before your lordship.
Show me that you have. That is the main challenge.
Yes, kindly take
Unless
that,
I pass some restraint order on that,
my lord,
I cannot pass any further order.
kindly take, my lord, page 64. Page 64. Lord, I've given a type copy, page 64A.
Hmm.
Lord, it's a longish order.
No, read the relevant portion, Mr.
My lord may come to page 69, my observation.
Yes.
In the light of the above, I can draw the following. The change of version of Miss Bidisha Achari. My lord, Bidisha Achari is the scrutinizer appointed by CDSL. And her statement that she stated wrong facts based on assumption and other clarifications forwarded by her raises a serious doubt in my mind, and I must minutely.
Who is making this decision?
Lord, the returning officer.
Please continue. Yes.
I must minutely explore the other facts to arrive at a true decision. Lord, may I pause here for a moment and give you lordship the background? Lord, the scrutinizer sent a draft report. After the election is over, Lord, the CDSL has appointed the scrutinizer. They have to, Lord, decrypt the online portal. They have to find out who got how many votes, and the draft report she sent to the returning officer so that he approves, and he will send the final report. The returning officer found out some flaw in that report and said that on that score only it is bad. I'll show your lordship that. Though admittedly, page 69, Ms. Bidisha Achari unlocked the e-voting system on 29 May 2023 at 10:41 a.m. She failed to provide the same to me and referred me to CDSL for the same. On the basis, I am compelled to presume that her report has not been produced on the basis of actual data, but there may be any other basis, maybe unholy, which I should not state, as the same should be investigated by the investigating agency as per the provisions of law to this effect, to unearth the truth and bring the facts in daylight. What compelling factors dictated her to use my name in her report, though draft, as a witness of unlocking the voting system? I don't know the reason behind this, but can easily suspect any unholy affairs being driven force behind this when I started getting some evasive replies from her. And lastly, in her final report, she took a 180-degree turn. The statement of Ms. Bidisha Achari is completely self-contradictory without any acceptable explanation, and as such cannot be relied upon, and I am not inclined to accept the final report. A copy of the same is attached herewith and is marked as Annexure F4. In the name of raw data, what she has been forwarded to me by Mr. Orgho Mojumdar is an Excel sheet which bear no mark of authenticity, no mark of the statement, whether the same is system generated or not, and not in compliance with the provisions of law relating to electronic evidence and electronic document. Being the document in contrary to law, I have no other option but to reject the document. What has been forwarded to me in the name of the system generated raw data duly authenticated by CDSL. A copy of the same is attached. Decision: on the basis of the above, I have no other alternative but in discharge of my duty as a returning officer for the election of the Board of Managers in Onhita Residents Association in 2023 to reject the report dated 30th May issued by Bidisha Achari, and also reject the document forwarded to me by Mr. Orgho Mojumdar, Deputy Manager, Business Development, CDSL, in the name of system generated raw data duly authenticated by CDSL, and declare the election null and void. So he disbelieved the data produced by CDSL as well as the final report of the scrutinizer. But kindly take the final report of the scrutinizer, page 85. I'm sorry, Milord.
Yes.
I so and so appointed for the purpose of scrutinizing the process electronic voting, e-voting for the election of Board of Managers of the association for the year 2023 to 2026 pursuant to the West Bengal Apartment Ownership Act 72, read with West Bengal Bylaws 2022, and the resolution passed by the special general meeting dated so and so, do hereby submit my report. Central Depository Services Limited was appointed by the members for providing e-voting platform at their special general meeting dated so and so for the election. In terms of the notice dated 1st May 2023 issued by the association for this election, the voting period for e-voting commenced from 12:01 AM on Sunday 28th May and ended at 11:59 PM on Sunday 20th May. The voting modules was disabled by CDSL for voting thereafter. After expiry of the voting period, the votes cast through e-voting were unblocked by me at about 10:41 AM on May 29, 2023. 219 eligible voters have cast their votes through e-voting.
What is the 180° he refers to?
Lord, in the draft reports, he sent Lord a letter through WhatsApp or through email,
I'll come to you, don't worry.
where she said that
Please take your seats, yes.
where she said that she has unblocked this in presence of the returning officer.
And used his name, that is agreement.
Yes, that is what happened is
That is somewhat suspicious.
that is somewhat suspicious according to my client's instruction.
Under the bylaws, is she required to do that before the?
No, under the bylaws, she is not required to do that. Under the bylaws, that is not stated in the bylaws.
But returning officer has the power under the bylaws to cancel this.
There is no power given under the bylaws.
What is the job of the returning?
We have selected the returning officer to conduct the election.
Very good.
The erstwhile board, we have decided that we will have the voting. The power under the act is very limited. It says that it has to be done in the manner decided by the members. So we decided e-voting. We appointed CDSL, the majority, and instead of Prithvish Ganguly.
Premise of rejection is apparently only this. His name was used. That is the primary.
I will show the draft report.
And he says something regarding the unblocking was not shown to him.
In
What is
the
the
draft
meaning of
report,
that?
kindly take the draft report vis-a-vis this note. Just give me a second. Draft report page ta bolo ki korcho. But just give me a second. Draft report, I'll give you a lot. Yes, page 76. Take it. Yes, page 77 kindly comes.
Yes.
Kindly see at the bottom the date, 29th May, and the final report 30th May. So see, I don't know why she has forwarded to she thought returning officer is above her. She sent it for approval. Kindly see, after expiry of voting period.
That is the difference. Returning officer.
Only that his name was used and the name of HON'BLE Mohapatra was used. But the data which was given, that is at page 78, all votes casted, everything is same. Lord, I tell you, Lordship, the returning officer was appointed by my learned friend's client, not in the meeting. Lord, he used to deal with their cases. I have made him a party. I have this allegation. Lord, when he found that the erstwhile vote is losing, he has found out this difficulty and we have cancelled the election. Lord, without going into this, Lord, the clients are.
So what sort of interim order are you expecting before going to them?
I'm asking for an order. I'm carrying 2 orders passed by my Lord Justice Mohsin Bhattacharya in case of Marlin's 5th Avenue and Obidipta apartment, where her ladyship appointed officers of your Lordship's court to conduct the election. Lord, I am not inviting your Lordship to go into everything. Mode was decided by us.
That will be a final disposal of the.
Lord, they want. Null and void, it is decided, so election has to be done. Suppose if we accept this order.
Then that can be done.
If we accept this order,
Yes.
then election, there has to be a re-election. Lord, I don't want that I get an interim order, somebody has to continue. I cannot continue today because the charge is not given to me. So if
You say the election be reheld and in the meantime some.
Election can be reheld within a period of 15 days, 20 days by your Lordship's officer. We will share the expenses as is done in sector Marlin 5th Avenue. Because if I get an interim order, that will harm me more. But if I get an interim order, then they will continue or either the administrator will continue after winning the election. So my prayer is appoint some of your Lordship's officer. We will bear the cost from the stage of special general.
In effect, you are not challenging the null and void thing, but you are saying to avoid all this.
I have challenged that, but to avoid that, my Lord may appoint, and that is their prayer also. They are also saying it is illegal. So they should not be prejudiced by this. Their term is over. They cannot continue.
What is your difficulty with Mrs. Meghnapal, WBCS?
Till such time the election is conducted, my Lord appoint some.
Why not she?
No, appoint an independent officer of your Lordship.
She's a government official, my lord.
And there is a supplementary affidavit. She has refused. Some retired officer has now been appointed by the competent authority.
Oh, she has refused already.
She has perhaps she has refused. Yesterday,
perhaps. What does perhaps mean?
I do not know why she has not. But the officer has been changed. Perhaps he has refused.
Changed by whom?
Competent authority. See, he has passed another order on 15th of June. Kindly take page 5 of the supplementary affidavit.
Give a copy to them
I have given.
We have received.
now.
No, we have affirmed it today morning. 15th it was served on us yesterday.
Very good. Yes, what is your objection to that? I mean, the
But if
election
there's-
gets cancelled in any
Yes.
event. They're virtually conceding.
No
So
objections.
let me
to
do that, whatever he's suggesting.
My lord, no objections to the cancellation. Ideally, my lord, it would have been better if the RO and the CDS would have been present, because perhaps the RO has got some points that the raw data was submitted without signatures and all that.
So regarding
we are
the
not-
nullity, actually, I'll not go into it because if
Well,
I
they are
have to
not
go into it, I cannot affirm that order or set it aside without hearing them. You are right on that. But since this stand is taken by the writ petitioner, then there is no effective challenge against that nullity thing. So if they have won and if they are not challenging effectively, then
Yeah.
what is the use of?
Because that challenge will take 6 months time. In the mean, because they will come.
Choose a common officer.
Anybody, your lordship, any officer of your lordship.
Who was appointed in the Marlin case?
Marlin case, Mr. Arjun Mukherjee, but he is conducting that election.
No, he'll not be. Yes. Who else? What will be the remuneration? What was the remuneration in those cases?
Lord, in that case, Mr. Mukherjee had to conduct the SGM also. Here the SGM is done.
What is SGM?
Lord, special general meeting where we decide the mode. So that is done here. So
He has to only conduct the
only
election.
conduct the election through CDSM. He will be the returning officer.
But he has to make the notifications also, the publications and all.
He will now
notification-
fix the date of election. He will now fix the date of election.
He'll ensure that the notice is given to all the
Notice is
members.
given through email to everybody. CDSL will conduct the election on a Sunday. He will be the returning officer. He will declare the result.
So choose an officer.
Yeah.
This is which area? Newtown area?
Yes.
Somebody from that region
Yes.
will be better.
One
Somebody not very senior. Both of you agree on a name? I'll appoint him or her.
Sector 5 follow থাকে huh? Yes, তার concept, Lord. May I come back at 2 p.m. with his concept?
The person's consent.
I can recollect 2-3 persons staying in Newtown. One is Mr. Pronit Bag. He stays in Newtown. It will be closer to his house. Second is Mr. Pallab Seth. He stays in Newtown, but he stays perhaps 2 buildings from that building.
No.
Maybe
So
interesting.
may not
He will be embarrassed later on.
He will be embarrassed. And Mr. Somit Bhanjo, he stays in Baguyati area. That would not be that far.
Mr. Bag will be all right, I think.
Mr. Bag will, but his consent, if my lord want me to take, my lord, Pronitke phone করতে, my lord want.
I'll
Mr.
make it
Monit-
subject to his consent. Pass my order right now.
or
If he does not consent, then mention it too. If he
Or
does not
not-
give his consent, mention it.
Till such time, your lordship passes the order. May I ask Mr. Mondal to call him and Lord inquire whether he is free or not?
Let me continue to pass my order in the meantime. If he does not agree, please tell me. I'll
Yes,
change the
yes,
name
yes,
only.
yes. জিজ্ঞেস কর প্রণিতকে প্রণিতে তোর কোনো অসুবিধা নেই তো
He knows whom better, you or him? Mr. Bag? Mr. Chakraborty? You are the problem, not Mr.
No,
Bag or him.
Nobody knows me, Lord. I am sure about that. Nobody knows. আমার নাম্বারই নেই ওর এখন
That's on a higher footing, in fact.
নাম্বার আছে
আচ্ছা,
তুই জোগাড় করে কথা বল
The new incumbents, who came in office in respect as the board of
board of
con-
managers board of managers of the respondent number 3 association. Yes.
Upon an election being held, have preferred the instant writ petition. Full stop. The challenge is two-pronged. Full stop. First, it was held by the returning officer subsequent to the election that the report submitted by the scrutiny officer was not in order and, as such, proceeded to hold that the election was null and void. Full stop. Next para. Thereafter, the competent authority has appointed an administrator to oversee the functions of the board of managers, including operating the bank accounts of the association for a period of 2 months from the order or till the new president of the association takes charge, whichever is earlier. Full stop. The competent authority also observed that it does not have the jurisdiction to adjudicate on the election dispute, but any interested party will be at liberty to move the appropriate judicial forum to adjudicate the instant dispute. Full-stop, it is argued by the petitioners that, first, the competent authority admittedly does not have jurisdiction to decide the election dispute and, as such, acted without authority in appointing an administrator. Full stop, next para, that apart, it is contended that Section 16, capital B of the West Bengal Apartment Ownership Act 1972, which has been invoked for appointing the administrator, is not attracted in the present case at all. Full stop, next para. However, learned counsel, by placing reliance on a supplementary affidavit filed with the leave of court today, submits that the administrator initially appointed was again replaced by the competent authority subsequently. Full stop, next para. Be that as it may, learned counsel for the petitioner submits that since no useful purpose would be served in the interest of the association in the event the imbroglio continues, imbroglio continues, the petitioner is agreeable to a fresh election being held, upon the order of cancellation of the previous election being maintained. Full stop. However, it is submitted that a court-appointed administrator may be given the power to perform the functions of the Board of Managers in the meantime and to oversee the elections also.
Yes,
And
as
to-
returning officer.
And to oversee the elections as returning officer. Full stop. Next para. Learned counsel appearing for the you are for which respondent?
Respondent number 3, my lord, the association.
Learned counsel
he
appearing
cannot
for the respondent number 3 association does not have any objection in principle to such proposition. Full stop. However, it is submitted that the election, you submitted something also? That if an order is passed on the merits of the election, outcome of the election,
Relevant respondents.
the other respondents ought to be heard. Full stop, next para. In view of the stand taken by the petitioners, however, Mr. Bagh is agreeable.
My lord, I have spoken with him, my lord, and he said that he might be traveling in 1 or 2 weeks, so he might not be able to comply with my
Very
lord's
good.
order.
কি বললাম?
May I take your lordship?
By the petitioners, there cannot be any further dispute regarding the election being declared a nullity. Full stop, since the petitioners concede to the proposition that a new election may be held, the same question, the said question need not be adjudicated unnecessarily in the present writ petition. Full stop. Accordingly, the as per the prayer of the parties, an administrator is required to be appointed for the purpose of performing the functions of the Board of Managers and the returning officer for holding a fresh elections. Full stop. The parties represented in court today are, accordingly, requested to furnish a joint agreed name for the appointment of administrator as indicated above. Full stop. Such name will be furnished. Furnish it on Monday. Furnish an agreed name. Take your time. Take consent and furnish the name. Such name shall be furnished on June 19, 2023, when the matter shall be listed under the heading to be mentioned
Lord,
for passing orders.
things, election to be conducted within a time-bound manner,
That
and
will-
his fees shall be paid by the association from the common fund. From the common. fund.
Elections
There's
are
a
held
fund.
from the common fund.
Yes, there's
So
from the common fund.
Good.
But I'm grateful to lordship.
Yes, what is the last gesture?
But I'm grateful to lordship.
What was the gesture? Show me. Newly acquired gesture. For the other court or some other courts? All courts. Call on the next one.
Item
Yes.
19.
May please your lordship. This is my application. I am for the petitioner.
Good service on all. Yes.
Petitioner,
The presumption is that your petition is a public interest litigation. So
No,
you
no,
go
no.
before the Chief Justice.
Lordship, very interesting. Petitioner doing
The
his.
Lord Friends is not interesting.
Petition, let me allow my submission. Petitioner doing his business on his ancestral property, who is become the entire land and building owner, private response number 6. Haji Saeed Ali Laskar.
Pardon?
Haji Saeed Ali Laskar. And his son is Matiur Rahman Ali Laskar. He has got a trade license from Kolkata Municipal.
So who is running business? You are running business. The petition
I'm running business
in his property.
in this property without giving, Lordship knows better than me. What says section 43? Duty to supply on request.
43 of what?
What is West
I
Bengal
don't say
Electricity
anything
Act,
on
West Bengal Electricity Act 2003,
West Bengal.
Electricity Act.
Oh, that
2003.
43 already.
Without giving any information, without giving any notice, how it can be done in accordance with law? Haji Saeed Ali Laskar has to go personally electric supply and
What has been done?
disconnect the line. No dues,
Whose line has been disconnected?
electric supply. West Bengal State Electricity
The
and Distribution.
electricity supplied to that premises.
That
It
premises,
was standing in the name of respondent number 6.
6,
That has been disconnected.
that has been disconnected. Bread and
You have come up
butter,
against that, yes.
yes.
You have served properly the licensee.
Lordship, kindly see page number 14, annex P2.
No. This writ petition has been served
Huh?
properly.
I've
You have
served
checked
up.
up. Very. Page 14.
Page 14.
You are for the licensee.
No, my lord. I am for the private respondent, the father of the petitioner, my lord. I have been driven out from the house.
These are the
I'm
two
driven out.
offices.
No, I'll come to it.
These are the two offices. Nowadays, from the beginning, very corrupted. One of the BLR, a block land and land reforms office. Any person have to go for mutation or porcha. I don't have money. You have money.
You're running a
You have
business,
paid
you
off-
said? You're running a business, you said? You don't have money?
No. BLR of block land and land reforms office, and another is West Bengal State Electricity District. But if you can imagine it, how type of behavior it is. Administration is not above the law. Administration is not above the judiciary. How it can be done? I am asking myself. Without giving any notice, Haji Saeed Ali Laskar has to go.
Who was the consumer?
Consumer Haji Saeed Ali Laskar.
Haji Saeed Ali Laskar was the consumer.
Consumer, private respondent number 6.
Owner of the premises also.
Entire land and
The
building.
electricity connection was in his name. He has got it disconnected.
Disconnected and pay the bill entire amount, no dues.
So he has got it disconnected. That is his right. It was not standing in your name. What is your locus standi to ask for reconnection? It was his connection. He has sought disconnection to harass you. But have you applied for a new connection in your name?
No.
Then you don't have any right over your father's electricity connection. You may treat it as your father's hotel, but you don't have a right, Mr. Shargar. No. His electricity connection, he has got disconnected. You have lost his favor. You must have done something to him. Driven away, as he's saying. No, Mr. Shargar. Is this a maintainable writ petition? You have no locus standi. Your father's connection has been disconnected at his request, and you are asking for that to be reconnected. Who are you? You may be his son, undoubtedly, but what is the locus standi?
Then at this stage, what I have to do?
You filed this after I had jurisdiction. Mr. Sharkar, this is you should be saddled with costs. I'm just afraid of you that you may start shouting. That's why I'm not imposing costs. That's the only reason. Otherwise, cost should be imposed on you. That's the only reason I'm telling you. Why shouldn't costs be imposed? Tell me. Independently.
If your lordship kindly sees the prayer, your lordship definitely will impose cost. Your lordship sees the prayer. He is trying to, my lord.
But just
stop me
remember
from-
this, now if I impose cost, Mr. Sarkar, your learned friend is liable, Mr. Shamul, not me.
My lord, he said that I am causing theft. I am causing theft, therefore it should be stopped. Your lordship, please.
No, Mr. Sarkar, you don't have a locus standard to maintain. I'll reject the application. Not impose cost, but reject the application. Learned counsel for the petitioner submits that the petitioner, comma, who is the son of the private respondent number 6, comma, is an occupant at the premises in question and runs a business therefrom, comma, which is the petitioner's livelihood. Full stop. However, comma, the respondent number 6, comma, who is the owner of the property and in whose name the electricity connection at the property stood, comma, had such electricity supply disconnected at his behest by the distribution licensee, comma, thereby depriving the petitioner from carrying on his livelihood and affecting the right to life of the petitioner. For next para, it is submitted that as such, comma, the said supply be reconnected. For next para, despite service, none appears for the distribution licensee, although the private respondent is represented through counsel. Full stop. Learned counsel for the private respondent submits that the petitioner has driven the private respondent out of his house and, comma, being thus fed up, comma, the private respondent has had the electricity supply disconnected. Full stop. Next para. Be that as it may, comma, the civil dispute between the parties cannot be adjudicated upon within the limited scope of the present writ petition, comma, which arises out of an electricity matter. Full stop. Next para. What is palpable from the records is that the petitioner, comma, not being the consumer of electricity at the premises, comma, is not entitled to ask for reconnection of the property, of the connection. Full stop. As such, comma, the present writ petition is not maintainable at the behest of the petitioner. Full stop. Accordingly, WP 13969 of 2013 is disposed of. Full stop. However, comma, liberty is given to the petitioner to apply for a fresh electricity connection at the premises, and in the event such an application is made, comma, the respondent number 1 licensee shall process and consider the same in accordance with law and give such connection to the petitioner subject to compliance of formalities, and if the petitioner is otherwise entitled to such connection in law. Full stop. Next para. No address to cost certain.
Before rising, may I have your lordship's deepest indulgence? Item number 28 of your lordship's the monthly list, the interim order is expiring today, my lord. An application is on, has been filed by.
It can only come in the list as to be under the heading for extension on Monday then.
My lord, if it can be.
Have you mentioned it already? In those slips it was there.
I had attempted to mention it on.
No, a bunch of slips was taken by me on Monday. It was not there.
That was
Give
not
the
there.
number.
And I am
Oh, the item number?
28 of your lordship's monthly list.
28 monthly list is সোমবার দিন to be for extension of interim order.
Deeply. The can number is not appearing in the monthly list. May I write the can and give?
Can is for extension?
My lord.
Yes, hand over. The extension application.
W.
2PA matter, item 91.
My lord.
My lord, this is a report, my lord.
Yes, the have you given copies to them?
Yes,
My lord, just now, I have.
Yes, because my lord, today's time I have.
Obviously, you did not get time.
So it's a one-page report, my lord, very specific. Paragraph 3 is the most pertinent.
But you have challenged that insistence to give an NOC.
No. My lord,
Just
I
remind,
prayed
please.
for. I prayed for, my lord, cancellation of the registration because the registration has been given at the address which is not to the society. They are not the tenant, nor they are the owner. Now, your lordship kindly sees section 5 of the act. It says memorandum of association.
Societies raised a or through.
Lord, I have got that. Lord, I have got that.
No, there's a classic কথা বললেন kneel down করাতে পারিস which section?
My lord, section 5H, 5,
Societies registration.
memorandum of association.
Societies registration, right? Please give a copy. Yes, thank you. Thank you. Yes,
Your lordship will find memorandum of association 1. The memorandum shall contain amongst the other things the following particulars, namely the name of the association, B, the address of the registered office of the association. So that is the compulsory requirement of law to give. Now, my lord, the issue is, my lord, whether A can give B's address as the registered office of his society and get it registered. Now, your lordship kindly come to page 27 of the writ petition.
yes.
That was the reply to the Right to Information Act. Page 27, item number 6. The
Right.
question was whether any land-related document was produced by the society or not. It is written, no land-related documents have been found with the file of the society. So
that basic
admitted
requirement
position.
has not been fulfilled.
Subsequently, my lord, in internet, they have issued, that is at page 49. That is the prescribed pro forma, how a no objection certificate on non-judicial stamp paper is to be filed. Your lordship mentioned that in your lordship's observation in the last order.
Yes.
So requirement for new registration. Number 3, NOC in non-judicial stamp paper from the landowner, standard format.
If this is not a mandate under the law, it's a procedure, then for this
Then
can the
my lord-
registration be vitiated?
My lord, my question, my submission before your lordship is this: the
Rule 5,
judgment,
section 5.
Section 5, number 1. Number 2, the judgment placed by my learned friend in the last occasion.
Yes.
The submission was that Section 21 of General Clauses Act is not applicable because it's a quasi-judicial authority. But I am placing, my lord, one judgment of Guwahati High Court. That is, my lord, the full bench decision reported in.
I will be relying on a honorable apex court judgment, my lord, which will set at rest all other judgments, my lord.
Your lordship kindly have a look at it.
Ling Seng Ning.
Full bench of Guwahati, yes.
Guwahati I relied on before Honorable Justice.
No, it says that the register has the authority to cancel the
No,
register. Yes, the judgment says, he is
Yes.
saying no.
But kindly have
The judgment is saying how adamant, and the state and the private respondent are going hand in glove.
Honorable apex court says otherwise. Kindly see, my lord. This judgment was hinged upon, my lord, in 2012 SCC online on the last day which I was filed. My lord, kindly come to, my lord. Para head notes and, my lord, kindly.
Guwahati full bench says that it is administrative in nature and not quasi-judicial.
But my lord, honorable apex court says section 21 cannot be invoked since, my lord, the register is a quasi-judicial authority. At best, he can opt for procedure for dissolution.
Which paragraph, Mr.
My lord, paragraphs I have written, my lord, by the side in hand. না আমার এখানে নেই আমার কপিটাই চলে গেল my copy has gone to your lordship erroneous.
So would you like to take this and
Yes,
exchange,
there is
exchange the copies?
Milord, para 17 and 41 are the context of the Milord case, and Milord then
Para 7,
17 and 41.
একটু রেফারেন্সটা বলুন না।
This is 2002 5 Supreme Court cases, page 685. India National Congress, I Institute versus Institute of Social Welfare and others. Now, my lord, the most fundamental principle of administrative law which was dissected here, my lord, is at para 20, 21 and 25. And so far as General Clauses Act are, that is at para 37 and para 39. Para 20, 21 and 25. Administrative law. Quasi-judicial function, meaning attributes of what distinguishes quasi-judicial act from administrative act. Test, where statutory authority is required to act judicially by holding an inquiry. This was absolutely relied upon by 2012 Delhi on the last day which I was handed over. My lord. And my lord, so far as General Clauses Act, it has been specifically dealt with in para 37 and 39. And my lord, relying on this judgment, my lord, 2012 Delhi concluded that only remedy available to the petitioner was to take recourse to the appropriate civil proceedings, my lord. That judgment I have already handed over to your lordship on yesterday. Only exceptional circumstances is the fraud. Para 41 and 34.
Exactly, here fraud has been done.
If fraud has been alleged,
vitiates every order, my lord, every action, my lord.
only then, my lord, section 21 can be. But there is, but here, my lord, in this case, there is no case of fraud or representation. We have never claimed, my lord, the property as ours. We have filed a suit on the ground of adverse possession. We produced our electric bill as a proof of our possession. My lord, we never claimed the ownership of the possession.
Your lordship has already held how the adverse position has been claimed. Your lordship has gone through that claim.
Allowed to submit it, my lord. And my lord, there was no column, my lord, or no paragraph, my lord, where we were to submit the proof of ownership in the prescribed format of the society registration for societies.
My lord, if your lordship kindly come to paragraph 12 of Guwahati High Court, that 2002 Supreme Court judgment has been dealt with, and that has been distinguished.
My lord, most pertinent para 37 and 39.
The Guwahati High Court is for the year 2019.
সুপ্রিম কোর্ট দেখাচ্ছি কি গৌহাটি হাইকোর্ট করছে। And my lord, Honorable Delhi High Court, my lord, in para 25, I have already handed over to your lordship. In the concluding para, have clearly opined, my lord, this should be left to the civil court.
My lord, Supreme Court is related to Representation of People's Act that was filed by for derecognition of a political
Cancellation
party.
of society was the moot point.
Paragraph 12 and 14.
Mr. Here, Supreme Court undoubtedly distinguish what is a quasi-judicial action, what is an administrative action. There are certain yardsticks for that. If it has to be in terms of certain statutory rules, then it's quasi-judicial, even if it's an administrative action. That was the basic test. Here, Guwahati High Court full bench has specifically observed in respect of this provision, Societies Registration Act, Certificate of Registration, cancellation.
Here
That is, it has been observed that that is administrative in nature and not quasi-judicial. So this is pat on the point, the Guwahati High Court full bench. So if it says it's administrative, not quasi-judicial, then it has been held by at least one of the high courts, the full bench, that this is not quasi-judicial at all. If it is quasi-judicial, then the Supreme Court order comes in your aid.
Honorable Apex Court says it's a quasi-judicial function. Hence,
That's a different function.
Section
That's-
21 cannot be invoked.
No, Mr. So probably not. That was an action of the Election Commission, which was of a quasi-judicial nature. It was held to be quasi-judicial, and then the rest of the principles are applied. But here, that was not in respect of registration of a society under the society's registration.
Deregistration. That was a case for deregistration.
That's an entirely
the
different thing.
petitioner applied for restoration of the registration.
This
No,
one.
Delhi High Court. In Delhi High Court.
No,
This
I'm
one
not
no.
speaking of Delhi. Now I am speaking
Apex
of the
Court.
Supreme Court.
Yes.
Supreme Court held, if it is quasi-judicial, then this applies.
Yes.
But unless it is quasi-judicial, administrative, it cannot apply. This says, Assam High Court full bench says, no, it's this action specifically is administrative, not quasi. So this principle does not apply at all then. The Supreme Court principles do not come in. Do not come in.
Then kindly.
Then your Delhi High Court remains, of course. But
Delhi-
that is a full bench and this is a single judge.
Then Delhi High Court kindly come to para 25, my lord. I have already handed over you.
Delhi High Court was in respect of Societies Registration Act.
Yes. Lord, then kindly come to 25. It thoroughly relied on the Honorable Apex Court's judgment, my lord. And I have also set out, my lord, different paras of the Supreme Court judge.
What was the Delhi High Court dealing with? Registration?
Yes.
Cancellation of registration?
Yes, my lord.
The fact was different. my
No,
lord.
no. Kindly see, para 2.
Para 5 also cancel.
Para 5 also, yes. The registrar proceeded to cancel the registration of the society on the ground that a false affidavit had been filed to the effect that the desirous person of the society are not related to each other by blood relation, whereas two members such and such and such and such, the petitioner were related to each other by bond, by blood, being father and son. The registrar invoked section 21 of the General Clauses Act to cancel the registration of the society. Consequently, the present petition has been preferred. Now, my lord, kindly come to para 23 straight away. One 5 and para 23. my lord. At this stage itself, as you lordship, I may take note of the recent decision rendered by this court in Supreme Court Bar Association by the Registrar of Societies decided on such and such. In the decision, reliance was placed on the aforesaid decision of the Supreme Court in Indian National Congress. My lord, that judgment I handed over. The relevant extract from the decision in the Supreme Court Bar Association
I also find merit in the petition submission that there is no power vested in the respondent number 1 to dissolve the society by resort to section 21 of the General Process Act in Indian National Congress. The Supreme Court examined the question whether the Election Commission has the power to deregister a political party once it has been registered. The Supreme Court held that the Election Commission, while discharging its function of granting registration to a political party, discharges quasi-judicial functions and held as follows. It was next urged by the learned counsel for the appellant that the view taken by the High Court that by the virtue of the application.
There are two components, Mr. Bandyopadhyay and Mr. Datta.
Yes.
One component is your challenge to the whether it is quasi-judicial or
Yes,
administrative.
yes.
If it is administrative, that's a common point between all of us, that if it's administrative, then probably we can look into, even if the power is not vested specifically, then also that can be assumed. If it is quasi-judicial, then it cannot be assumed as per all these judgments. Now, that is one aspect of the matter. Let us suppose for the time being in your favor that it is administrative, this power can be assumed. Even if that power is assumed, Mr. Bandyopadhyay, how do you justify? Because the notification as per the state itself, for which I sought the report, is not mandatory under the law.
Yes.
It's a procedure evolved by the authorities. Now, procedure, whether it has attained the status of a custom or convention, I don't think so. There is nothing on record to establish that. If it is not so, then whether for non-compliance of a procedural policy introduced by them, whether the registration itself can be vitiated, Mr. Bandyopadhyay. Satisfy me on that also.
Your lordship kindly sees the paragraph 3 of the report says it starts with like this: in order to avoid any dispute regarding the registered address. Now the registered address is mandatory. Now whether a person can get registered today, tomorrow, my lord, if I apply showing High Court as the registered office of a society, will the registered allow that application?
These are analogies, my lord.
Will not allow. Similarly, my lord, if third party's address is shown as the address, whether the register has done justice in without, especially when, my lord, they have acknowledged that no land related documents have been submitted.
That
Then
registration was not challenged ever before any forum apart from the registrar himself.
Yes.
You have challenged that registration. You have challenged the registration before the registrar himself.
Yes.
No, before this honorable court earlier.
And this honorable court relegated you to the registrar.
Your lordship kindly sees Justice Mousumi Bhattacharya's order. Your lordship has.
Let us see. Let me see that.
My lord, kindly see page 25 of the Delhi High Court.
My lord, your lordship, if your lordship kindly get your lordship's order,
Page 25 of the
that
Delhi High
will
Court.
be clear. Your lordship kindly sees your lordship's order. Just the previous one or the just before that.
Page 20.
Elaborately has dealt
of
with,
the-
my lord.
Para 25, my lord, of the Delhi High Court.
No. Coordinate bench held that a direction, you had made a representation before the registrar,
Yes.
which was directed to be disposed of.
Yes.
Now
Only
your
this.
lordship's order
Only this.
kindly
That does not confer jurisdiction,
Yes,
Mr.
yes.
Bandyopadhyay.
your lordship kindly sees.
Justice Mousumi Bhattacharya was pleased to observe that the writ petition is disposed of. You have made a representation with a direction on the register of firms and societies to dispose of the
Yes,
representation.
Yes,
Merely that.
Without going into the merit, my lord. It has been
What merit?
stated
Merit
here.
has to be dealt with. Your lordship kindly
Sir,
sees
please
your
take your
lordship's
seat for
order.
the time being.
Your lordship kindly
Hello.
sees your lordship's order, my lord.
I am reading from my order only, 6 June order.
6 June. I'm just coming.
Second paragraph.
No, that is, but subsequently your lordship has given observation, my lord. I'm just coming to that portion.
Mr. Bandyopadhyay, there are two questions only involved here.
Quasi judicial or administrative?
Quasi judicial or administrative is the first question. Second, supposing it is administrative, if I hold in your favor on that, then Mr. Bandyopadhyay, whether this calls for a cancellation of the registration. The violation of a particular provision, which is not a mandate of the statute or any rule formulated under statutory guidance. This is not a legislation. This is a procedure adopted by the authorities. They can very well adopt procedure, but does it have a statutory backing or a sanction?
My lord, if statute, then what will happen? Your lordship kindly visualize
Registration
the
cannot be cancelled for that.
your lordship kindly visualize the practical problem, my
It
lord.
is irregular,
Here,
but
my
not
lord,
illegal.
here there nobody of my premises, but still It's a refugee rehabilitation scheme. The person got it from refugee rehabilitation scheme, my lord. So it has been transferred twice before me.
Suppose, Mr. Bandhavata, let us take an extreme case, not even an extreme case. Suppose I fraudulently produce a deed before the authorities, the registrar, and it is registered. That deed is either fraudulent or executed by my henchman before the registering authority. I produce the deed. Can the registrar go into the inquiry whether it's a valid?
Certainly civil court will do everything.
If the registrar can't do that,
Cancellation of.
then where is the scope of that inquiry? Where does it lead to?
My lord, the inquiry
That is
leads-
my query to you.
Primarily, the registrar failed to appreciate the statute because the provision says the address of the society must be given. Now, a address has been given, which is fraud. So if fraud is
Mr. Bandhavata, your dispute is different. Your dispute is that, yes, you are entitled to that property. Wrongly, the cooperative society has obtained registration in respect of that and doing whatever.
my lord, mutation, tax receipt,
Yes,
everything
you have a
is in
case.
my-
You have a case. But Mr. Bandhavata, on merits, so whether the question is whether the registrar could have decided this at all.
My lord, if the statute fails, the High Court will
Statute
come.
has not failed.
If the statute does not prescribe anything specifically.
CPC prescribed. Section 9 is there.
Right, then my lord, your lordship kindly sees, first your lordship has to decide
You
whether
go
it's
before
a-
civil court, I can give you that liberty.
your lordship.
This is a civil right.
My lord, they are waiting for that chance.
They are working and they are jumping, or literally jumping. Mr. Datta is jumping.
Actually, and
That
the
does not
state
improve their
government, and
case.
they are, my lord, of the court I am mentioning, my lord, one minister residing in New Alipur area is dealing with the entire case.
He's
And
close
this
to
is
Mr.
a-
Datta also.
Yes, yes.
He's close to Mr. Datta.
That I do not know. That I do not know with the private
Must be.
respondents.
The way he's jumping.
And your lordship kindly sees the submission of the state government and the nexus between the state government. They are practically.
Mr. Bandhavata, I can be fully agreeing with you regarding the interference of some minister, although I don't know in this matter. But maybe some case I am fully agreeing with you. In some case, it may be. I have personal knowledge, suppose. Even then, can I do this? I mean, I have to be within the law. So if the
your
minister does something illegal, definitely order will be passed.
So your lordship has to decide whether.
How can I
it's a
decide these propositions?
Quasi judicial or administrative.
Even if it is administrative.
Then your lordship kindly can pass the order because of the Guwahati High Court judgment. That is the full bench judgment.
No. Guwahati High Court empowers. I am proceeding on your premise, Mr. Bandhavata, that it is an administrative order. So let us assume that. Administrative order, yes. If it is administrative order, then even without having a specific power, the registrar can invoke this power of cancellation. It can undo what wrong it has done. But the question is, Mr. Bandhavata, on a different footing. Even assuming that the power is there with the registrar, even then, if there is no statutory violation, if there is a violation of a particular procedure which has been invented by the authorities for their administrative convenience, they're entitled to. But violation of that, can they reject the registration?
Your
Or can
lordship
it be
kindly
cancelled on a higher footing?
They have committed fraud. Why? Because
That
the
you
registered
have to
address-
agitate in a civil suit.
The memo,
Street
no,
court cannot
my
decide.
lord, memorandum says, section 5 says, address of the society must be given. Now, if by fraud, the address is given, then what will happen? My lord? Your lordship kindly decide that.
That is exactly what I told you, Mr. Bandhavata.
Number 2, my lord.
Your
your
answer
lordship
is
kindly-
no, the civil court has to do it. Because
Your-
if a fraud is perpetrated,
Your-
the registrar cannot go into that inquiry whether it actually belongs to the society or not.
Your lordship
No,
kindly
it is
come-
produced, they'll accept it just.
Your lordship kindly come to section 22, my lord, of the act, section 22.
Section 22.
22. That is the power of register to call for information or explanation. The registrar may, by written order, call on a society to furnish in writing such information or explanation within such time not being less than 2 weeks from the date of receipt of the order by the society, as he may specify in the order in connection with the affairs of the society or any documents filed by the society under this act. So if the society does not submit any document relating to land or the premises, then what will happen? Here, the registrar invoked that section and called for record relating to land from the private respondent. And RTI application says that they have not submitted any land related documents.
Then there has to be an inquiry under section 22.
Section 22, by invoking that, the registrars called for that report, I mean land reported document from the private respondents. Next, it is not applicable, but a hint may be got, that is section 25, dissolution by court. The court may, on the application of the registrar or on the application of the not less than 1/10, this goes against me, my lord. 1/10 of the members make an order of the dissolution of a society in the following case: if there is any contravention by the society of the provisions of this act. So court has the power to cancel, but that is a different thing. I have already mentioned, my lord, that the first two lines goes against me, but the court has power in case if there is any contravention by the society of the provisions of this act. So certainly there is the contravention.
Not related to cancellation.
Acha, at the time of the registration,
my lord,
is any public notice contemplated under this statute?
No.
There is no.
No.
So,
Look, those are relating to internal affairs of the society, those 25, 26, 22, etc.
that is different. Very well, Mr. Pondopadhyay, but even on that score, you cannot succeed because this is not a statutory violation. I'll give you liberty to approach the civil court.
Yes.
You can challenge that registration, that component of registration on several other grounds.
Your lordship kindly sees the
Yes.
fate of the petitioner. Civil court means 15 years. They are a money person. They will come to High Court already on the basis of that adverse position suit, my lord. They have preferred the injunction of the. It is as their matter of right, my lord. They have come. They will exercise again those rights.
The adverse person they have claimed already here.
Now, if we go to civil court, my lord, your lordship knows how the
Adverse
civil court-
person cannot be. I mean,
that is a separate thing. For cancellation, if we prefer an application before the civil court, my lord, your lordship has the best knowledge.
no,
how
that
civil
is
court-
true, Mr. Pondopadhyay. It will take several years.
But when the fraud is apparent, my lord, then will the High Court not do anything? My
The
lord?
fraud, I am worried on the question of fraud. If we call this fraud, then Mr. Pondopadhyay, many things will be frauds, because the fraud you are alleging is contravention of a procedural norm of the authority, of the registration authority,
So it was the
which
duty
only
of-
says that yes, this document has to be there, but it is not mandated by the statute nor mandated by the rules. So I am on the the violation. There are two components. One is assumption of jurisdiction. On that you are right. Suppose you are right. It's administrative. They can assume that power. Even if they assume that power, that has to be exercised on some ground. The ground you are taking is violation of a particular norm which has been set in force by the authority, which is not there. That authority is also not there. The authority of the authority to introduce such norm, that is not a statutory power. If the statute said that the authority can formulate its norms, then I can understand there's a statutory force behind it. Here it is neither a mandate of the statute, nor the rules, nor they have been empowered to do this.
My lord, now your lordship.
So where
will
is the
appreciate-
contravention of something fundamental?
Now, my lord, your lordship kindly appreciate why the registrar asked the private respondent to submit the record relating to land.
Because of the
It was-
direction of the coordinate bench that he has to
No, before
decide.
that, before that,
yes.
before that. Now, the case is like that. A
Mr.
thief,
Pondopadhyay, at this stage, we cannot probably open up the issue.
my lord, a thief has been caught. Now he had been produced before the police station. Now the police is doing, there is
a
no
good analogy.
provision. So what
Not
will
a
happen?
good
my lord?
analogy. This is whether this is theft or not, is arguable.
My lord,
Because the title of the good which he has stolen allegedly, that is in question.
my lord, your lordship,
Question has to be decided by some authority.
your lordship is prima facie satisfied that a fraud has been taken place, because they have made the
Can I decide on the question of fraud, Mr. Bandhavata? I am primarily satisfied that you
we
have taken out a very valid point, fraud, an argument has been made, an allegation has been made. Up to this, I am satisfied. I am definitely not satisfied that there has been a fraud. How can I be satisfied without
We
taking
have
this?
a strong belief in your lordship's acumen and everything, my lord. Your lordship
That
decide
is
the matter.
misplaced. There also there is a jurisdictional error.
Your lordship kindly
There
decide
also
the
there is a
matter.
jurisdictional error on your part.
But
the
Guwahati,
other
you
aspect of the
specifically
matter,
keep
Mr.
in mind regarding the Guwahati High Court judgment. That is a three judges bench specifically stated register has got the power. If it is missing, then how Guwahati High Court has that has not been challenged. And
Mr.
that is the
Bandhavata, in the
29th
facts of
judgment.
this case, I have to bypass that question. I'll decide. I'll right now decide. I'll say whatever pleadings, arguments you have made. I'll record all those, both of you. But I'll say that that issue need not be decided here because of the reason that if it is decided, even then you are not entitled to interference by a writ court. That is the reason. I'll give my reason in my order. That question need not be decided here. I could decide that question. That would be an academic exercise, Mr. Bandhavata. That would embellish the judgment. Nothing else. I would ensure that it is reported somewhere or something like that.
So
Nothing. Your purpose won't be served. His purpose won't be served.
His
I'm being
purpose
very
will be
candid.
served. His purpose will be served.
If
So
it is
the-
delayed, then it will be served.
It will be.
So then
it
I'll
will
not
be.
delay it. I'll decide it right.
My lord, nobody is alien to the legal system, my lord. And my lord, the petitioner is going to be crucified. That is it.
I have full sympathy on that, Mr. Bandhavata, but I cannot do something. I may think I have this power, but I don't have this power. This is a constitutional power. My powers are very limited. Within that, I can do whatever I like. I don't not whatever I like by giving reasons. But beyond that, I cannot act. So what I cannot do, I won't do. So
Then, my lord, your lordship kindly record that
everything I'll record. Everything I'll record. Two moot issues have fallen for consideration in the present writ petition. Full stop. The petitioner has challenged the veracity of the registration of the which respondent is the society?
6 to 8. 6.
6 is the society.
6 to 8, my lord.
6 to 8 cannot be the society.
No, my lord, 6 is this society. 6 is the
Of the registration of the respondent number 6 society under the West Bengal Societies Registration Act, 1961. Full stop.
My lord, actually 6 is the president, my lord. He has implemented the president, secretary, and my lord, two other members. He's implemented the president. Secretary has not, the society has not been implemented as a separate entity. my lord.
Registration of the কি বললেন এটা এই জায়গাটুকু কেটে দিয়ে registration of us society তারপর যা বললাম stop. Next para, it is argued that in view of the said society having not furnished all documents as per the extant regulations, comma, the said registration ought to be cancelled. Full stop. Next para, it is further argued by the petitioner that the petitioner is the allottee of the said property, comma, in respect of which the society has obtained registration, comma, by showing the same to be its property. Full stop. However, comma, the same was done by perpetrating fraud patently, comma, on which score the petitioner made a representation before the registrar of societies. Full stop. Initially, the registrar had called for the relevant records from the society. Full stop. Subsequently, by virtue of a direction of a coordinate bench of this court, comma, the registrar decided on the representation of the petitioner. Full stop. However, comma, the registrar refused to recall the registration or cancel the same. Full stop. Next para. The first question which has arisen is whether the function of the registrar in registering a society and stroke or cancelling such registration is an administrative or a quasi-judicial action. Full stop. A subsidiary question there too is, comma, if administrative, comma, whether the registrar could assume the jurisdiction to cancel the registration subsequently upon discovery of a violation of the statute at the time of registration, comma, by deeming such power to be vested in the registrar within the contemplation of section 21 of the General Clauses Act. Full stop. Next para. Secondly, comma, on merits, comma, whether the petitioner was entitled to an order by the registrar for cancellation of the registration awarded to the society in question, comma, namely the Ramgarh Shiv Mandir Unnayan Samiti. Full stop. Next para. In respect of the first issue, comma, learned counsel for the petitioner cites cites a full bench judgment of the Guwahati High Court reported at AIR 2019 Go 3 within bracket নামটা দিয়ে দিও Atwar Rahman versus State of Assam and others for the proposition that the order of cancellation of certificate of registration is an order within the meaning of within double inverted orders double inverted clause under section 21 of the General Clauses Act as well as Assam General Clauses Act. Full stop. Registration, a registrar, comma, it was held, comma, can cancel registration of society after giving opportunity of hearing to the parties. Full stop. Next para. On the contrary, comma, learned counsel appearing for the respondent numbers 6 to 8 cites a judgment of the Supreme Court reported at 2002 5 SCC 685 bracket namta de Indian National Congress bracket I versus Institute of Social Welfare and others to argue before the court that the Supreme Court clearly distinguished between a quasi-judicial and an administrative function. First up, it was held by the Supreme Court that in case of quasi-judicial functions, comma, powers cannot be arrogated by an authority to itself. Full stop. While so distinguishing, comma, the Supreme Court had been pleased to observe that a quasi-judicial act is one which has to be according to the rules within bracket statutory bracket closed, whereas an administrative function is dictated by policy and expediency. Full stop. The Supreme Court, comma, while so discussing, comma, also entered into the subtle nuances of the interplay between the two and discussed the situations where there may be ingredients of both. Full stop. Next para. Learned counsel for the respondent number 6 to 8 also cites a judgment of a learned single judge of the Delhi High Court reported at 2012 SCC Online Del 2535 bracket Brij Mohan Gupta versus the Registrar of Societies bracket closed. Full stop. By placing reliance on the said judgment, comma, it is argued that the Delhi High Court placed reliance on the Supreme Court judgment which has been cited by the respondents and thereafter went on to proceed on the premise that an act of registration stroke cancellation by the registrar under the Societies Registration Act is not an administrative but a quasi-judicial function. Full stop. Next para. It is thus argued by the respondents that the quasi-judicial function exercised by the registrar cannot be saddled with a power which has not been vested statutorily on the registrar. Full stop. Next para. Learned counsel for the state, comma, as per previous direction of court, comma, files a report which indicates that there is no provision for registration of a society in the 1961 Act and rules thereunder, requiring the submission of documents, that is NOC in non-judicial stamp paper, related to the premises or land where the registered office of the society is proposed to be situated. However, comma, it has further been disclosed that in order to avoid any dispute regarding the registered address of the society, comma, the office of the registrar of firms, comma, societies and non-trading corporations, comma, West Bengal, has made the submission of NOC in non-judicial stamp paper by the owner of the land stroke premises where the registered office of the society is proposed to be situated, comma, mandatory as a necessary as a usual procedure, comma, although there is no specific provision in the act and the rules made thereunder. Next para, learned counsel appearing for the petitioner, comma, taking a cue, CUE, from the said report, comma, submits that under section 5 of the 1961 Act, comma, subsection 1 within bracket small b mandates that the address of the registered office of the association has to be contained in the memorandum. Full stop. Hence, comma, since such mandate flows from the statute, comma, it is argued that the production of relevant documents in that regard is necessary. Full stop. If a fraud is practiced on the authorities by the person seeking to get a registration, comma, it is open to the registrar to reopen the issue of registration, comma, since fraud vitiates all. Full stop. Next para. As regards the second question, comma, which is interconnected with the above discussions, comma, it is also submitted that in the present case, comma, the registration having not been obtained properly by production of documents on non-judicial stamp paper pertaining to the consent of the owner of the land, comma, which is the petitioner, comma, the said registration itself is vitiated and the registrar could very well cancel the same. Full stop. Next para. Learned counsel for the petitioner has also placed reliance on sections 22 and 25 of the West Bengal Societies Registration Act 1961 and argues that the power of the registrar to call for information or explanation vested under section 22 would be a toothless formality in the event the registrar did not have power to cancel the registration. Full stop. Even in the present case, comma, section 22 within bracket 1 was duly invoked by the registrar, comma, which indicates that section 22 is applicable to the present case. Full stop. Moreover, comma, even the court can dissolve a registered society, although the prerequisites for the same are not applicable in the present case. Full stop. Next para. Heard learned counsel for the parties. Full stop. The first question which has arisen is regarding whether the power of the registrar to register a society under the 1961 Act and or cancel such registration is an administrative function or a quasi-judicial one. Full stop. Next para. Although the Supreme Court judgment cited on behalf of the bar, from the bar deals with the cases where distinctions between quasi-judicial and administrative functions have been laid down, and the same has been followed by a learned single judge of the Delhi High Court in the context of the said principle being applicable to the Societies Registration Act, comma, thereby conferring power to the registrar to cancel or reopen the registration itself, comma, sorry, not to cancel or reopen the registration itself, comma, the judgment cited by the petitioner is that of a full bench of the Guwahati High Court, comma, which also has strong persuasive value. First up, in the Guwahati High Court judgment, comma, it was clearly observed that the powers of registrar as regards registration of society is administrative in nature and not quasi-judicial. Full stop, next para. Hence, comma, it was observed that order of cancellation of certificate of registration is an order within the meaning of orders under section 21 of the General Clauses Act. Full stop, next para. A careful consideration of the provisions of the statute does not reveal that there is any power vested on the authority granting registration, that is the registrar, comma, to recall the order of registration or to review the same. Full stop. Although there is no specific power of cancellation vested in the registrar under normal circumstances, comma, undoubtedly the registrar has power to call for information or explanation under section 22 by a written order, comma, in cases where the registrar deems fit. Full stop. On receipt by the society of an order under subsection 1 of section 22, comma, it would be the duty of the officer concerned to furnish such information or explanation. Full stop. Subsection 3 thereof provides that for failure to comply, comma, there is a token sanction provided under the statute by way of a fine. Full stop. Next para. Carrying on further, comma, section 23 of the Act vests power on the state government to investigate the affairs of a society where on information received, comma, the government is of opinion that there are circumstances suggesting that the business of a society is being conducted with intent to defraud its creditors, comma, members or any other persons, etc. Full stop. Section 25, comma, which is for dissolution by court, comma, provides that the court may, comma, on the application of the registrar or on the application of not less than 1/10 of the members, comma, make an order for the dissolution of a society in certain cases. Full stop. The said cases also include that if there is any contravention by the society of the provisions of the Act. Full stop. Next para. Hence, comma, a clear reading of the different provisions of the Act reveals that the registrar does not have the power to cancel registration, comma, once granted. Full stop. Rather, comma, section 23 provides section 23 vests the state government with such power to investigate and take corrective measures in the event there is any subsequent mismanagement in the affairs of the society after such registration. To sub next para, even the court has been vested with a power, comma, but only on an application of not less than 1/10 of the members of the society or an application of the registrar. Full stop. One can easily link the provisions of section 22 of the power of the registrar to call for information or explanation with a following application by the registrar before the court for dissolution under section 25. Full stop. In such cases, comma, however, comma, it is not the registrar, but, comma, on an application of the registrar or 1/10 of the members, comma, that the court has the authority to take up such issue. Full stop. Next para. In the present case, even without going into the disputed issue as to whether the function of registration is a quasi-judicial or administrative function, it is seen that the cancellation sought by the petitioner before the registrar is something which is beyond the scope of the registrar. First up, even assuming the best case of the petitioner, that the registrar had a power to reopen such registration, the issue raised by the petitioner is the contravention of a mere technical provision introduced as a matter of convenience by the Office of the Registrar of Firms under the Registrar of Firms. Full stop. Next para. However, as admitted by the Registrar of Firms in his note, there is no provision for registration of a society under the Act or the rules made thereunder requiring submission of the document by way of an NOC in non-judicial stamp from the registered owner, which is the alleged violation canvassed by the petitioner. Full stop. Next para. That apart, on a more basic premise, it is evident that only a civil court has the jurisdiction to decide on the allegations made by the petitioner to the effect that the society in question has sought to usurp the land of the petitioner, to which the society does not otherwise have power. Full stop. Such question can only be raised before and addressed by a competent civil court having jurisdiction to take up such issues, and not decided by the registrar of the cooperative societies as well as by a writ court, without taking detailed evidence. Full stop. Next para. As such, even if the contravention of such procedure introduced by the registrar's office was done by the respondent society, it cannot be said that the same authorizes the registrar of this registrar under the Societies Registration Act to cancel the registration outright and or recall the order of registration. Full stop. Next para. Hence, there is no scope of interference in the present writ petition. Full stop. However, it is made clear that it will be open to the petitioner to approach the competent civil court with the disputes regarding title to the property on which the society in question has shown its registered office to be situated before a competent civil court. Full stop. If such issues are raised, the said court shall decide the same in accordance with law, without being prejudiced or influenced in any manner by any of the observations made herein. Full stop. WPA 1861 of 2023 is disposed of accordingly in the light of the above observations. No address to cost.
Grateful to you.
Sorry. Yes. I'll keep this on record.
Yes.
Sir.
There's no.
এই বইটা ফেরত আর এই বইটা ফেরত দিও বইয়ের নামটা কি দেখে নেবে বলে দাও নাকি যে নামটা দেখে নিয়ে তুমি
Grateful to you.
Thank you
for having given us a very patient
No, no.
hearing. Right, well.
ওইটা একটু পরে নিয়ে নেবে না স্যার
দাও ডাকো
92,
92 yes Acha 315 I have given liberty to another person to mention.
I will not take long.
I mean, I'm just indicating to you, so you may be disrupted at 315. Because those are also urgent matters.
বলে দিই না ডিসকানেক্ট করবো না ছোট অ্যারেঞ্জমেন্ট করে কয়েকদিন বাদে রাখো করে হবে
Yes, Monsieur.
No, I was, my lord, overhearing or trying to overhear.
My lord, in reality, my lord, my learned friend might finish. My lord, the
Even for my lord interim orders, it may not finish by 3:15. So my lord, may I make a suggestion? My lord, I have spoken, my lord. My lord, no, my lord, steps will be taken. My lord, next week, my lord, whenever your lord. I don't want to, my lord, unnecessarily, my lord, be, my lord, unfair to the court and to our client.
Thank you so much, Mr. Mukherjee, for prevailing once again.
Only for this consumer.
No, no, my lord, it's, my lord, we understand pressure, my lord. I am facing it, your lordship is facing it.
So give me an agreed date on which Mr. Mukherjee, Mr. Mojumdar and Mr. Mitro and Mr. Datta will be free. Mr. Chakraborty may not be free, but otherwise, although he is leading all of you, but even then.
At least, my lord, he had the perseverance to get the matter fixed.
He has many other qualities also, but
And my lord,
he will
get
get
all of us
too
here.
related. Yes,
And get
no,
all of us here.
convince all of you also. Right.
Because his goodwill, my lord.
Absolutely. On bona fides, we cannot say anything. So when should I keep it? Monday may not be a good date because Monday several other matters.
Wednesday at 2 p.m. I have a fixed matter, my lord, a second appeal I have to argue. But any other day.
Thursday at 2 p.m. Thursday at 2 p.m. any difficulty? Thursday কিছু fix আছে? কবে ফ্রি আছে দেখো ধরুজি ফ্রি আছে পরে সব বৃহস্পতিবার শুক্রবার ফাঁকা আছে 2 p.m.
Thursday, 2 p.m.
Thursday 2 p.m. then. Mr. Mukherjee, should I record anything or it will be an understanding?
No, only Thursday, 2 p.m., my lord. I think that should be.
Very well. Due to paucity of time, Mother Babu, due to paucity of time, the hearing cannot be concluded today.
Disconnection.
Full stop. Let the same be adjourned. Let the matter be adjourned and shall next be listed for being taken up at 2 p.m. on today we are on June 22, 2023. 22nd June. Next Thursday.
Lord, if I may say one thing, my lord.
Yes, Mr.
There are 6 other matters against the TVC.
Mr. Chakraborty wins.
My lord, I prevailed over in one, my lord, kindly.
No, I'm not passing it out. No, those will appear along with এটা দিয়ে দাও এগুলো দিয়ে দিও ওর সঙ্গে দিয়ে দিও এগুলো ওর সঙ্গে যাতে appear করে
My lord, the assurance to your lordship, my lord, is in respect of this.
only in this matter. Only this matter is appearing in the list.
Yes. No.
Others also appearing. I have taken up only this matter.
Yes. Yes.
Others will be disconnected.
হচ্ছে না।
তুমি অত মনোমালিন্যতা আরম্ভ করবে।
ডাকো যতগুলো পারা যায় ডাকো।
Item 20.
Yes, you are for the petitioner. You are for the petition. This also paucity of time, Mr. Bandyopadhyay, since you are appearing.
It's 5 minutes, 20. But I need not even open the brief, my lord.
Mr. Bandyopadhyay, is there any scope of interim order?
It should be disposed of. No scope. There's no scope of affidavit also, my lord.
Oh, very
My
good.
lord. Section 14, order of the district magistrate
Already
authorized.
the order has been executed and one writ petition is pending before the Honorable Justice Raja.
You are for the state.
No, my lord, I am for the private respondent and one Baglihati police station case.
You wanted an expeditious disposal of the section 14.
No, Section 14.
So what is the prayer in this?
My lord, I am not allowed to speak, my lord. Section 14 has been disposed of. The district magistrate authorized the executive magistrate, my lord, to carry out the order.
Oh, that's it.
Then he fixed, my lord, it was passed in 22nd October 2022. Now till today, the executive magistrate didn't have the time, my lord, to execute the order. Because my lord, the position.
The executive magistrate, Mr. Bandyopadhyay, has authority.
Because the district magistrate has to, my lord, authorize someone, my lord, to carry out. My lord,
Right.
He fixed the date on 12th June. My lord, by WhatsApp message, my lord, he deferred it. My lord, we arranged the police. My lord, we had to arrange the. My lord, we had to inform the police stations. My lord, that
You are the financer.
I am the financer. Now,
Already it has been disposed.
Let him just finish. Yes. So that is your grievance, Mr. Bandyopadhyay.
only the executive magistrate, my lord, kindly take, my lord, page 44.
And Mr. Bandyopadhyay, what was the pendency of some other writ petition?
But there is no stay. It has been recorded in the order of the district magistrate.
They have filed the said writ petition before the court number 13.
Well, that's
give him the microphone, Mr. Mondal. Let me hear him first. Then you will give in your reply. You will say whatever. Yes.
Milord, the
Who has filed that other writ petition?
Aditya Birla Finance, as the petitioner
Against what? Yes.
has broken the law.
That is on a different footing.
Yes, Milord. And one Bagwihati police station case number 201 of 23 on test passing for 450.
You say the section 14 has been
Yes, my lord.
implemented.
Yes, my lord.
Executive magistrate has,
Yes, my
has
lord.
done
I
what?
filed the affidavit with all the document. Read petition, Bagwihati court, Bagwihati.
No, after that you broke the padlock and entered again.
Yes, my lord. Already it has been executed. My lord, kindly give me 1 day's time. I will
Appoint Mr. Kishore Datta and Mr. Swarup Pal as amicus curiae in this matter. They're very happy with this. Mr. Datta and Mr. Pal will be the amicus curiae in this matter.
Now may I submit, my lord?
No, Mr. Bandhavadda, if it has been already implemented, then what?
Let me, my lord, submit, my lord. If someone is, my lord, tries to confuse your lordships, my lord, I don't have to be blamed.
Nobody has to try to confuse me.
My lord, yes, my lord, there are 3 properties. My lord, separate proceedings are there under separate section 14 proceedings. These confines to a single property. Because it has some territorial, my lord, limits. My lord, this has, my lord, 3 different mortgages. For one mortgage, my lord, read applications was earlier filed, my lord, for implementing the order of the district.
This is pertaining, this section 14, regarding this, there has not been any other application.
No. This pertains to, my lord, the land, my lord, kindly come to page 44. That is why, my lord, the
44, yes.
order starts at page 43.
44 is irrelevant.
44 is relevant. Therefore, after careful, the affidavit including the clauses mentioned under section 14, such and such, and all other relevant, which the secured creditor filed duly affirmed by the author, such and such, the secured creditor being satisfied is hereby authorized appointed executive magistrate. But for taking possession, kindly come back to page 43. That is the descriptions of the property.
No, that order has already been passed by the district magistrate.
Yes, now you also will see the executive magistrate was appointed by the district magistrate. He needs to carry out this. He needs to take possession. I cannot go and take possessions. It is his duty. Will arrange the police.
So executive magistrate is not a party here.
Yes, yes. He is the Sudip respondent number 2.
Achha, very well. Number 2. Yes.
Yes. This was done in 22nd October.
So this is all, Mr. Bandhavadda.
This is they have to now he fixed a date. Now he cancel. Kindly come page 45. That is the we arranged the police, we paid the required charges, then he cancel. This is the WhatsApp communications. Kindly check the last 2 lines. He initially fixed, our authorized officer had gone to the police stations, arranged the police.
His profile picture may be the reason for not being possible. His child,
that is his
a little small child. That may be, he also may be the reason.
12th may not be possible. Kindly see, now it is around 8 months have lapsed. Even the provision says it should be completed within 1 month.
What do you say?
Kindly see page number 36.
36, yes. What is it?
Taken possession in a single. All the 3 property. Property 1, property 2, and property 3.
Kindly take page 43.
And all have been broken.
Mr. Bandhavadda, just let him finish. Yes.
For different properties, there are other.
So this is a schedule.
Yes.
This is a part of that.
Yeah. My order is related to page 43. Kindly come the first paragraph.
This is not a report by the executive magistrate.
This is the schedule. And
where do I find that it has been executed by the executive magistrate?
File the affidavit, my lord.
If it has been executed, then you cannot have any grievance if I direct it to be disposed. The executive magistrate to then the executive magistrate will. I'll direct the executive magistrate to comply with the order of the district magistrate and file a report before this court. That will clear the issues.
Yes. Already one read application and
Is there any stay in the read application? When was it filed? They have filed, that's their headache. They are denying. I'll record that.
WPA 116.
I'll record that, Mr. Bandhu, this is not your writ petition.
Yes.
Not regarding this property.
Not regarding this property. My lord,
Madhav, একটা order নিয়ে
kindly record my name.
Learned counsel for the petitioner argues that the petitioner had obtained an award long back under the SARFAESI Act.
No, there is no award under.
There is no award.
Section 14. There is a under the order.
Very well. The learned counsel for the petitioner contends that the petitioner
They followed the procedures.
Followed the procedure under SARFAESI Act 2002 and obtained an order from the district magistrate concerned, that is the respondent number 1, comma, under section 14 of the said act for taking possession of several properties, including the property involved in the present writ petition. Full stop. Subsequently, the district magistrate, comma, by an order
No, my lord, that is the only order.
dated
Before that, there was no
October
order.
20, 2022, comma, directed the executive magistrate, that is respondent number 2 herein, comma, to implement the said order and take over physical possession of the scheduled property, and to have a spot videography being made in connection with the taking over of such physical possession of secured assets on the date of taking over possession. Full stop. Next para. Soft copy of the videography was also directed to be kept under the custody of the executive magistrate. Full stop. It is contended by the petitioner that despite such direction, comma, the executive magistrate has been stalling the implementation of the order of the district magistrate. Full stop. Learned counsel also places reliance on annexures to the writ petition, which are purportedly printouts of social media communications by the district magistrate to the
By
petitioner.
the executive magistrate. My lord.
By the executive magistrate to the petitioner, indicating that the fixed date for such execution, that is May 12th,
No, 12th June, my lord. 12th.
12th June, this is.
Yes, the first.
Sorry.
12th.
That
may not
is
be
June
possible.
12, 2023, comma, may not be possible. And he would let the petitioner know the suitable date later. Full stop. Such printout has been annexed at page 45 of the present writ petition. Full stop. Next para. It is, comma, thus, comma, submitted that the proceedings are being stalled indefinitely without the private respondents having obtained any order of stay from any forum whatsoever. Full stop. Next para. Learned counsel appearing for the private respondent submits that a different writ petition has been preferred by the writ petitioners herein, comma, which is now pending. Full stop. It is submitted that apart from such pendency, comma, the executive magistrate had actually implemented the order of the district magistrate and taken over possession. Full stop. However, comma, subsequently the possession was again taken by the present private respondents. Full stop. Next para. Pardon?
Well, on behalf of state lordship, though I have no instruction as such, but my humble, if I want to take instruction, then it will take some time. Only thing, my lord, may I tell?
Yes.
That, my lord, one single instance of failure, my lord, to act on the basis of, my lord, earlier, my lord, intimation. That does not mean that, my lord, that he, my lord, that he want to stall the, my lord.
I'm not finding
My God, my lord.
Acha, একটা line
There
quote
may
করি।
be some reason.
Learned
that-
counsel for the state respondent submits that a single instance of non-implementation of the order on the part of the executive magistrate
On the scheduled date.
on the scheduled date may not tantamount to deliberate violation of the direction of the district magistrate. Full stop. Be that as it may, comma, at the present juncture, comma, the private respondents have raised a question as to the executive magistrate having already acted in terms of the order of the district magistrate in the meantime. Full stop. Such contention is disputed by the petitioner both by verbal arguments as well as by their pleadings in the present writ petition, comma, substantiated by the WhatsApp communication annexed to the present writ petition. Full stop. The next para. Hence, comma, it is required to be ascertained first as to whether the executive magistrate has taken over possession in pursuance of the order of the district magistrate. Full stop. Next para. Accordingly, the respondent number 2 shall furnish a report to the court within a week from date, comma, indicating as to whether the respondent number 2 has implemented the order of the district magistrate in the meantime by taking physical possession of the secured assets in terms of the order dated October 20, 2022, passed by the district magistrate, bracket A, annexure P3 at page 43 of the writ petition, bracket close, full stop. The matter shall next be listed on June 26, 2023, when such report shall be filed in court, with advance copies being circulated to the learned advocates for the petitioner as well as the private respondents. Full stop.
An affidavit of service filed to.
Affidavit of service filed to be kept on record. On the premise of that, Mr. Bandyopadhyay, I'll pass my orders and Mr. Shen also.
But he is confusing. Schedule, the property is there in the order.
Apparently yes, but even then, the last communication also, so there is nothing on record to show.
There are
Anyway, if he gives the report, then I'll pass the necessary orders.
3 minutes is there. But 23rd June, Malar, then
26th June.
26th June, Malar.
Report will be ready by that, before that, by 23rd, but it will be filed on the next date. Yes, call on that.
3 minutes is there, Lordship.
Pardon?
3 minutes is there.
Oh, yes, 3 minutes is there.
Item 21.
Yes.
Lordship, in this matter, Lordship, the court directed the finance department to submit a report. Lordship, I think the state advocate is not there, Lordship, because he has changed. He is no more in the panel, Lordship. So, Lordship, grant me liberty to serve a notice to the GP and take it up there on Tuesday, Lordship.
None appears for the state when the matter is called on for hearing. Full learned counsel for the petitioner submits that in view of a change in the state panel in the meantime, comma, it may be, comma,
He has informed us. He is no more in the panel.
Acha, comma, it may be, it has been informed by the erstwhile learned advocate for the state that he is no longer appearing in the matter. Accordingly, leave is sought by the petitioner to serve a notice on the office of the government pleader. Next para. Such prayer is granted. The petitioner shall serve a notice on the government pleader at his office, intimating the government pleader that the present writ petition shall be taken up for hearing. Give me a date.
Tuesday.
Taken up for hearing on Tuesday, that is June 20, 2023. The petitioner shall file a receipt in that regard on the next date of hearing.
Let it remain in the same position, Lordship.
That is very difficult, Mr. Bala.
Lordship, there is urgency, that is why it's upgraded, Lordship.
I know, but
it's an upgraded motion, Lordship 1. Lordship, let it be.
So what is the urgency?
Lordship, actually, Lordship, there is a terms in the tender memo.
Cook diet?
No, Lordship, it's a Lordship, it's a cook diet, Lordship.
Lordship,
what are the
cook diet?
Lordship, the clarification sought for the clarification submitted by the state was dissatisfied with the court. Court stated that the finance department would clarify. That has not given, Lordship.
Mr. Paul, there are several similar matters of similar urgency.
No, Lordship. This clause is not, Lordship. This clause is
urgency, on the urgency.
Lordship, that without giving the explanation, they are floating tender, Lordship, finalizing the tender, Lordship.
When will the tender be finalized?
Lordship, tender
floated already.
Lordship, they are floating tender be defined district, Lordship. Lordship, let it be remain in the list, same position.
Definitely in the list, but not
the
in the
same position.
Same position cannot be assured.
Lordship, let's.
There will be other matters, new motions will be coming in.
But it's an upgraded motion, Lordship.
Even then. সোয়া তিনটে
315 matter, item 74.
Yes.
May please, Lordship, I am for the petitioner.
Even notice to the other side, Mr.
Yes, yes. And notice. Madhusudan Sahara is appearing. I saw. Well, what happened in this matter?
Yes.
Petitioner purchased a house consisting of 6 kata of land and 50% he purchased. So
50% demarcated.
demarcated and purchased the portion of the said building. The CSC authority is going to install a pole transformer. My lord, I have annexed a picture, page 10, annexure P2.
You raised your objection in writing.
Yes, I made a legal demand of justice in time. They did not pay any heed. Thereafter, I served it petition. They received. They did not consider that.
Your building is the Day's Clinic building.
And my daughter will be the doctor and it will be her chamber. First, secondly, entrance. My daughter is
Yes.
MS gynecology. So,
Yes, Dr. Sahara.
May I submit?
Search out an alternative location.
No, there is no alternative location. For this reason, I have stated. Lordship, kindly hear me for a moment. This is the Howrah locality. And there is a huge demand of electricity in this scorching heat. And we have received series of complaints on that aspect. There was already existence of 2 transformers. Apart from that, in order to cater that, because there is a disruption of electricity in several occasions, and we have been mishandled by the local people in several occasions. Now we have inspected the place, and on that pretext, the road where my learned friend is saying it's not his road, it's a road of a municipal road. And we have already intimated the Howrah Municipal Corporation. Inspection has been made. Your Lordship, kindly see the photographs for a moment. What my learned friend is saying that we are stopping the ingress and egress, it's not correct. If your Lordship kindly see, it's a huge building.
This is just from a different angle.
Different, yes, but
The same photograph is there in the there.
this is what I have shown the color photograph where if your Lordship will find that this is a huge building. It is not that it is on the road. And
why pat in front of the building?
Because there is no
Just immediately adjacent.
And your Lordship see in the adjacent place there is a one shop. Chicken shop is there also.
Chicken will also suffer.
No, they are not, because otherwise your Lordship public interest will
Several acts come in. Cruelty to animals and other acts are also there. So no, you cannot install there.
But there is no other place, Lordship.
They must have rubbed you up the wrong side for some reason.
But there is no other place. At present, there is
the
no
usual tactic of the
it is-
government.
but it is
This is the CSC or WBS?
CSC, Lordship.
CSC is also doing this.
There is no other alternative place. It is technically feasible, only that place, Lordship.
I'll ask for a report, but don't install it there. This is pat in front of the house, Mr.
But
Dr.
this is,
Shah.
your Lordship, kindly see that this
It's
is
an old house. It was there for some
It is
time.
an old house, and this is the old house. It is not a new house. And on that basis, your Lordship, the road where my learned
The
friend
transformer is new. The house has been there for
the
long.
transformer may be the new, but that your Lordship, no, now it is not a oil transformer. It is now a dry transformer, and the safety measure we are taking care of that.
That is the electricity office of the office of the CSC in the Howrah area.
433.
It is nearby this place.
Then I have the 433, your Lordship. 433.
Near this place.
In the GT road, it is the place, Lordship.
I'll direct it to be installed there.
But then how it can be catered to that place? In that locality, it is necessary,
This is
Lordship.
just in front of the house. The entire house will be in jeopardy. This is an old house in any event. Just look at the house in the photographs. You look at the house yourself.
I have seen this.
There must be several residents there.
It is absolutely, gap is there. There is no objection on that pretext, Lordship. No one, there is a other place also in the locality, and there is also 2 transformers.
Furnish a report in their presence, have an inspection, furnish a report, you will show an alternative location.
Let them show the alternative locations.
They'll have to.
Yes.
And in the meantime, they will not.
No.
Let them show the alternative location on
How
that.
soon can you do it?
So, not there.
You have to excited.
Mr. Halda says he will show. He will be there. I'll direct him to be there also.
Yes.
So when, how soon?
Lordship, may I may?
একটা order record.
Wednesday.
Learned counsel for the petition, I'll give it 2 weeks. Oh, Tuesday, very well. Learned counsel for
Wednesday.
Learned counsel for the petitioner submits.
Because there is some sort of urgency here, because there is
Obvious.
in a squashing
Learned
on.
counsel for the petitioner submits that a pole transformer is being sought to be installed by the CSC Limited immediately in front of the house of the petitioner, comma, thereby preventing the ingress and egress in front of the gate of the said building, comma, which would affect the petitioner in several ways adversely. Full stop. Next para. Learned counsel appearing for the CSC Limited submits on instruction that although the photographs annexed to the writ petition depict that there is a transformer coming up in the said location, comma, the same would not in any manner prevent the ingress and egress to the property of the petitioner. Full stop. Next para. However, comma, a prima facie perusal of the photographs annexed to the writ petition raise a sufficient prima facie question as to whether the petitioners are justified in seeking an alternative placement of the said transformer, comma, on apprehension of serious risk to life and limb of the petitioners in the events the location is not altered. Full stop. Next para. Accordingly, the CSC Limited shall hold an inspection upon prior notice to the petitioner and in the presence of the petitioner or the petitioner's duly authorized representatives within June 21, 2023. Full stop. Upon such inspection being held, comma, a report in that regard shall be filed on the next returnable date, that is on June 23, 2023, when the matter shall next be listed. Full stop. An advance copy of the report shall be handed over to the learned advocate for the petitioner before the next.
One pair, let them show the alternative place also.
Very well. Arekta line add korin. During such inspection, comma, the petitioner and or her authorized representative shall identify a suitable alternative location for the shifting of the transformer in question to the CSC personnel.
My lord, in the there will be no work. That point, my lord.
The CSC Limited shall not proceed any further with the work of installation of the transformer till June 30, 2023 or until further order, whichever is early.
May I submit one thing that will be clarified, Lordship? Lordship, kindly fix a date on Wednesday at 12 p.m. Let them be present there, let it be reflected on the order. So that no.
Pass my order, Dr. Shah. No, let us not waste further time. Yes. Give a notice tomorrow, hold it on Wednesday. Because the other side, there is no other side. So you have to serve only on them.
No, Lordship.
Do it.
We are there to cater the load. That's why you are for the public interest, Lordship.
Especially for public interest. Let's just see the location, Dr. Shah.
Item 22.
Yes.
I am appearing on behalf of the
My
petition.
lord, the respondent.
You're for the respondent?
My lord.
Well, the learned counsel for the SEBI has offered a solution. My lord, I'll come to that.
You'll come to that means you are not agreeable to that.
My lord, I have my reservation. My lord, the issue is there is a previous order passed by my lord Justice Mantha. In that, the liberty has been given to SEBI to take two options, either to set aside the sale and retender, and his money to be adjusted, and other one is to give him an opportunity of hearing and, if possible, extend the time to file the. The issue is the difference.
That is your prayer in the.
That is my prayer. My prayer is in my case, my lord.
Yes.
The auction was declared successful at 2:30 in the 2:40 in the evening, my lord. I could not make payment because at 3:30 my bank closed. The payment was made within 10:40 possibly.
They're willing to give you an opportunity to participate.
Yes, my lord. They are willing to, my lord. The problem is Problem is the whole discretion has been given to me. In my case, my lord, there is no question of interest because there is delay of not even 24 hours. I have made the full payment, the requisite payment within 24 hours.
There is a clause that you have to pay interest.
It says no. The clause says that
Either you are eligible or you are not.
no, clause says the successful bidder has to pay immediately. The word has been used immediately. Now, my lord, when I was declared in the mail which I was declared successful, it was stated you make the payment today. I attempted that. It is not an issue.
Not, it was on the next word.
Next 10:30, my lord, 10:40 next.
So they're agreeable now. Oh, they are wanting to reopen the tender.
That's
Say you are
remains.
successful and your payment was valid.
Valid.
So you should be accepted at the success.
My lord, reasonable, on the ground of reasonableness. 24 hours I have made the full payment. They cannot say that you have violated the stipulation.
So you have made out your case on merits also.
My lord.
What is your answer to that?
My lord, we are not floating another tender, my lord. My lord, my instruction is that, my lord, there are certain regulations which has to be followed by the recovery officer of SEBI, my lord. As per that, my lord, the payment option is open till.
Please take the microphone a bit.
My lord, the payment option is taken till he makes the payment on very that day. My lord, because of that.
Just show me the relevant clause. Satisfy me on that. Whether it's immediately or very same
My
day.
lord, kindly comes to page number 60. Sorry, my lord, 20 of the petition.
20.
Clause 6, my lord.
Yes.
My lord, immediately the successful bidder shall deposit the 25% of the
Clause 6.
successful
Oh,
bidder.
immediately.
Clause 6, my lord.
Where is the immediately?
Second line, my lord.
Second line. my lord.
Read the entire sentence. The successful shall have to deposit 25% of the successful bid amount immediately after
close of the auction.
close of the auction.
And balance with 1% of the highest bid amount at poundage fee of within 15
And
days.
the auction
from
was
close
to
of-
close when?
The same day, my lord. My lord, it was auction was declared on 13th.
Date and time of the auction was up to 12:30 p.m.
My lord, 13th March.
So then immediately means immediately after.
No.
Immediately
Well, I
after the
was-
close of auction, you have to put in
My
there.
lord, once it was informed to them, they had to make the rest of the payment, my lord.
That is different.
And
But
my
they did not make that payment, the initial payment also.
No.
Initial, my lord, they have done, but the rest.
Earnest money has been paid. Second is 25% of the. My lord, kindly imagine we did not have any idea.
No, the immediately qualifies the first payment.
I know. No, immediately, yes, my lord. The
Immediately
first
after
25%.
the close of the auction,
Successful bidder. my lord.
25%. So you
25%.
did not, you deposited that 25% one day after.
Within 24 hours, my lord. Not even one day after, my lord, within 24 hours. Because I was declared successful.
Yes,
my lord,
reasonableness. Why not reasonable? I mean, immediately after the close of the auction,
My lord,
they were
hours,
within
my
24 hours.
We don't.
And I
have
did
any-
make some payment on that day because
No,
my
we
lord, the
don't-
bank closed 3:30 and I was able to, because my bank.
No, you had
closed.
3 hours in between.
My lord,
3 hours. You had 3 hours.
No.
Should have been ready with the money.
2:30, my lord. You'll kindly see their mail.
No, 2:30, the time of the
40,
closure of
I
the-
was declared, man. It was declared on.
Oh, acha, 2:30.
Two-
Within 1 hour, they could not do it. I mean,
No, my lord, we are not.
At page
we are
42,
not
my
saying
lord.
that we are not going to accept his money, my lord, after that time, my lord.
Then-
The problem is with the regulations, my lord, the payment options closes, my lord. For that, my lord, our previous date has been filed, which has been submitted by my learned friend, my lord, wherein, my lord, 2 options were given by Justice Mantha so that we can accept their bid after closure of the tender, my lord. So that is the order. This is the order, my lord. Can
I'm
see
giving
this.
copy.
regarding the same tender.
My lord, it's not same, it's a
Similar,
different
similar.
issue, my lord. But the issue was the same.
My lord,
Tender
yes,
was
my lord,
different,
kindly
but
That is there. No proposition of law has been laid down here.
no, my lord.
No,
My lord,
no,
only.
very interesting fact, my lord. Kindly see the first paragraph. He was given 2 opportunities of hearing. 25th, not put to bid money despite opportunities given on 25th March and 28th March. He was given 2 opportunities. I was not given any opportunity. In that case, opportunity was given to him on twice. In my case,
So you want to give similar opportunities to them
My
also.
lord, my lord. We are agreeable to give them the same opportunities as
If you
they
accept their bid, if you accept their amount, then they are the successful bidder.
My lord, we are saying that they are a successful bidder, my lord, but only the amount we
Problem is
cannot
that-
accept, my lord, because of the closure of the.
they are saying.
So now you are ready with the amount.
Yes, it's 15 days.
Paid within 3:30 today.
My lord, 15 days time, my lord, it as per regulations. But 3:30, my client is.
It's already 3:30. It's already 3:30. No, file it by tomorrow then.
My lord, the stipulation says within 15 days. My lord, I am, because I have to talk to my client. He is in
Oh, this is regarding the balance amount.
balance amount. My lord. Balance amount, I am ready to pay. My
So
lord.
accept that. If you are willing to accept, I'll record that you accept
My
that
lord, we
he
are
is
willing to
acceptable.
accept it,
My lord.
Proceed with the rest of the bit.
My lord, then give, how much time do you want to pay?
My lord, my
Rest
attempt, my
of
lord,
the amount, whatever is the
my lord, my specific instruction is 15 days as per the notice. Notice gives me 15 days
if
to.
the initial deposit is accepted by you, the rest follow its course
15
as per
days.
this schedule.
My lord, my
So
lord.
they'll have to adhere to this
My
schedule.
lord.
Yes, yes, yes.
My lord.
Of course. My lord.
Learned counsel for the petitioner argues that as per the clauses of a notice inviting tender, comma, pursuant to which the petitioner participated in the e-auction and turned out to be the successful bidder, comma, 25% of the successful bid amount was to be deposited immediately after the close of the auction. Full stop. Next para. Although the petitioner was able to put in a part of the said amount of 25% on the same date, comma, however, comma, due to a technical snag in the online payment on the end, at the end of the bank in question, comma, the entire payment of 20%, 25% could not be completed within the same date. Full stop. However, comma, by 10:30 a.m. the next day, comma, the entire payment was completed. Full stop. Next para. Hence, comma, it is argued that the principle of reasonableness demands that the expression within double inverted immediately in clause 6 of the tender document is interpreted to be 24 hours and to accept the petitioner's deposit as the successful tenderer. Full stop. Next para. Learned counsel appearing for the respondent authorities submits that in a similar matter, comma, a coordinate bench had given certain options to the petitioner, which may be adhered to in the present case as well. Full stop. The first option was that discretion was conferred under the orders of the court to the regional manager of the eastern region of the SEBI in the interest of recovery process and the object and purpose of recovery under the SEBI Act, comma, to confirm the sale in favor of the petitioner after granting of further extension. First of the second option was that the auction is conducted afresh and the writ petitioners therein participated, allowed to participate therein. First up, in the present case, comma, the respondent authorities are agreeable to the first option for the present writ petitioner as well, insofar as the SEBI shall accept the deposits made by the petitioner to be valid deposits in terms of the notice inviting tender. Full stop. However, comma, it is submitted that the petitioner is also required to put in the rest of the balance amount in terms of the tender document. Full stop. Next para. Learned counsel appearing for the petitioner agrees to do the same. Full stop. Accordingly, comma, there is no use of further keeping the matter pending since the dispute between the parties has been resolved on principle. Full stop. Accordingly, WPA 6619 of 2023 is disposed of by accepting the offer of the respondent authorities to accept the petitioner's deposits, comma, made in terms of clause 6 of the tender document to the tune of 25% of the successful bid amount, comma, as a valid deposit in terms of the said clause. Full stop. The tender process shall now proceed in accordance with law and in terms of the bid document, and the petitioner will be deemed to be a successful tenderer, comma, of course, comma, subject to the petitioner complying with the rest of the terms as per the tender document. Full stop. No rest to cause urgent certificate.
My lord, may I humbly submit the next matter, my lord, item 23, my lord. The analogous matter I have, my lord, 130 and 139. May your lordship can kindly just bring to lordship. Can
This is the matter, Mr. Hadi was
No,
23 I'm submitting, my lord. 23 and 138, 139, they are analogous
No, no,
matters.
not
my
like that. 23, let 23 be heard tomorrow, let us see.
lord. They are analogous matters.
Analogous, similar.
138,
They were directed to be heard together.
not directed, madam, but they are analogous 138 and 139.
Mr. Ghosh, you had mentioned the matter on some occasion. You are there behind.
138,
You are in the other matters. Same parties.
No, parties are not all same, my lord. State Bank is party in 23. Most probably State Bank is not party in 133.
Are you affected? Is the main order sought against you?
No, in 23 is against me.
It is educational loan application made by the.
If they're connected, let them appear together. একসঙ্গে দিয়ে দাও কালকে. Please give the numbers in a slip of paper.
But those are relating to other banks. Other banks.
Then the respondents have to be informed. No, then no tagging. State will be taken up tomorrow, especially. No, the other matters cannot be tagged with this. There's a different banks. Let this matter be decided first, then we'll decide on. Yes, Mr. Samanta, you say, Mr. Hadi, I'll come to you.
We have, it was an election dispute. Now they have, the moment we wanted urgent, they have sent an order. Therefore, it has to be disposed of. Lordship will take it up on Monday.
Infractious.
Yes, it has become.
Then I'll direct it to appearance to be mentioned. I'll record that.
But then they should get notice also.
So when should I keep it? Tell me.
2 PM on that day, subject to my lord's.
I'll keep it as a to be mentioned. To be mentioned matters appear fairly at the top of it.
Because I will only play one thing, Lord, so that the ballot boxes are kept intact. Because I'll have to challenge the final order.
Give the ask Leonard Junior to give the number of that in a slip of paper. Otherwise, this will be misplaced. We'll put that as to be mentioned on when?
Monday or
Monday, very well. Monday তাহলে to be mentioned রেখে দিও।
Well,
লিখে দিচ্ছেন ওনার জুনিয়র লিখে দিচ্ছেন না?
my item at 25, my lord.
It will be taken up tomorrow after the new motions. On Monday, I'm sorry.
My lord, that is the due to Bakrid, my lord. That is I am suffering, lord.
Bakrid, when is the date, Bakrid?
That is the good one is going to be held for 20th.
Let us see if I can take it up on Monday. Let the goats survive for some time.
So item number 26, Lordship, it has been filed by the state challenging the order of the National Human Rights Commission.
National Human Rights
Commission regarding the Panchayat election and role of the state.
That has become infectious.
Now, Lordship, we belong to various political parties. If your Lordship passes any
various
order,
political parties or one political party, Mr.
Kindly hear us. I am for one political party. And because I have to, if your Lordship pass any order, we want to apprise your Lordship on certain facts on that. Lordship, not today. It's going.
Is this a caveat being lodged by you?
Not caveat, Lordship.
So,
I'll be.
Are you sure that I'll remember this when I take up that matter? And I can assure you I will not. When the matter is called on, if you are entitled, I'll give you a hearing. Otherwise, I won't give you a hearing. What is the occasion of mentioning it today?
We have no occasion, Lordship. I just want
Just because you are here, you have to mention. Probably your other members are also here, party members. No. When the matter is called on, please mention whatever you have to.
Mr. Hadi's matter, I am with him, my lord.
You're also there, yes.
Yes, my lord. After the order is passed, it is to be communicated to at the Delhi office, and this formality is to be completed. So, my lord, unless it is heard by Monday, it will be infructuous because.
That's very well. If from Monday, I'll be taking up in the morning, I'll be taking up the appellate side matters. I expect some more matters to be taken up. Up to 3, I'll be taking up.
Within my lord,
So I hope I'll be taking up this matter now. Up to 3 PM, I'll be taking up appellate side matters. Even after the recess, I'll continue.
We are expecting that.
So if I can take up the matter in due course, then I'll take up. If I can't, then come back at 2:15 and remind me that I gave you the liberty. Mention it. I'll take it out of turn. Give a notice to the other side. Give a notice to the other side, Mr. Chakraborty, that it will be mentioned at 2 if it is not taken up in due course.
All right.
আজকের 38 নম্বর